She was awarded the prestigious ICSSR Senior Fellowship Award in 2016-2017. She has been inducted as an independent woman director in the Gujarat-based PSU. She is member of high-level committee constituted by Ministry of Corporate Affairs, Government of India, for preparation of investigation manual for Serious Fraud Investigation Office. She has published many articles on emerging area of law, specifically corporate law, corporate social responsibility, insolvency and bankruptcy laws, etc., in various journals and book chapters. Dr. Biswal has participated and presented various research papers on contemporary themes of law in international and national conferences, seminars, and symposia. And now, without much further ado, I would request Professor Biswal to kindly take over and further this session. Over to you, ma'am.
Thank you, Advita, for such a long introduction. Good evening to all present here. Honorable Chairman of this round table, Mr. T.K. Viswanathan sir, who is the pioneer and who has played instrumental role and key role in developing insolvency laws in India, apart from other achievements told by Advita. The speakers from different countries. Let me introduce this round table and the speakers to the chairman. So the idea behind this round table is just to know the impact of UNCITRAL model law on cross-border insolvency in different jurisdictions. Because in India, we are in a very advanced stage now for the adoption of the UNCITRAL model law. And we have the speaker, Mr. Unnikrishnan, who was a member of the committee. And I don't want to speak about the law in India now. So the background is that when we are in the advanced stage and because of COVID, there are lot many changes to the practice. So just to exchange the ideas about the impact of the model law on cross-border insolvency in various jurisdictions, and I have already mentioned few points that whether the different jurisdictions and particularly the speakers who are present in their jurisdiction, whether the UNCITRAL model law has been adopted or not. If adopted, is it effective? And if it is effective, how the model law has been incorporated in the domestic law, either as a domestic law or a separate law, and also to know that if the jurisdictions they have not adopted, what law they are following. So the idea is that after this deliberation and discussion, we will come to know that what exactly is happening in the world with regard to cross-border insolvency. Because if I talk about India, then after the Jet Airways case, I think we all are very concerned, and our government is also very proactive to bring the law, and the high level committee also has recommended, and there are committees where Mr. Unnikrishnan is a member, and he will speak about all those things. So that in this where India is in a very cross juncture at this stage because of all this development and COVID-19 crisis. So here just we want to know, and we all can exchange the ideas among ourselves about different jurisdictions. And without taking much time, very quickly, I'll just introduce my colleagues and speakers in this roundtable. So we will have Professor Lapi from Jordan, Professor Jason Kilburn from USA, Professor Leon Trackman from Australia, Professor Wei Meng Sing from Singapore, and Professor Stephanie from France. She will join little late. She's in a meeting now. And Professor Rajendra Prasad Gunpot from Mauritius, and Professor Panayotis from England, Professor Gabriel from Argentina, and we have the speaker from India, Mr. Mithil Krishnan, and the moderator will introduce all the speakers. Just as a formality, I introduce the speakers to our chairperson, and now thanking all of you for consenting to be part of this roundtable. Now I request the chairman to chair the roundtable. Thank you so much, sir, and thank you, Adi.
Thank you, Professor Biswal. Thank you very much. Thank you, advisor, for the opening remarks. Uh, am I audible? Can you hear me? Can you hear me?
Sir, yes, sir.
Okay. No, good evening and good afternoon and good morning to all our participants from across the globe. And let me first start with a short background of how we came about drafting this legislation and how we succeeded after two abortive attempts which were made earlier. The Insolvency and Bankruptcy Code 2016, which was enacted by Parliament, is a landmark legislation for many reasons. For the simple, India has a very rich statute book, and amending any law will require a lot of consultations because many ministries will involve, and there will be a plethora of laws. So to bring everything under one single umbrella legislation is a marathon task which we had to achieve. I had drafted, I have been a parliamentary draftsman for more than 3 decades. I have drafted many legislation. So the former law minister, who was the finance minister, Arun Jaitley, so entrusted me with this challenge. And he told me, Viswanathan, you try your luck with this piece of legislation, because he was also not very hopeful at the beginning, because you have to take too many participants into fold, consult them and bring them on board. But we succeeded. My team did a very excellent job. We had great inputs, and we were able to draft the legislation under one heading, entire personal insolvency, corporate insolvency, and we also put in a lot of efforts to bring in the infrastructure. But one thing was missing in the whole exercise was we did not provide for cross-border insolvency. And I was the first person to be called by the Joint Parliamentary Committee, which was examining the bill before could be passed. And they, in fact, members asked me two things. You have not provided for cross-border insolvency. Today, in a globalized scenario, assets are all distributed, scattered all over the world. How do you propose to deal with this problem? I said, I am aware of this problem, but already we attempted too many impossible things and we succeeded. But then this has to wait. We didn't have the necessary ecosystem to give effect to the cross-border element for the simple reason we did not have a dedicated bankruptcy tribunals or courts. We didn't have a single law dealing with the insolvency or bankruptcy. We didn't have the information utilities, and we didn't have the means of having joint holding of sessions between foreign bankruptcy courts. These are all things which were missing in the beginning, and it was too ambitious task to attempt in one go everything. So we gave it up. But the parliament introduced two clauses, two sections into the code to deal with cross-border insolvency and bankruptcy, and they are all based on bilateral treaties. No, since the institutional backup like the ecosystem was not available, I did not provide. But the parliament supplemented it by providing for two sections through the bilateral route. So bilateral treaty exactly is not the most efficient way of achieving cooperation between jurisdictions. A dynamic legal framework and rules are needed to deal with cross-border issues, which a treaty cannot be a substitute, because bilateral trade agreements will be dependent upon long-term negotiations with each country, and agreements will differ from country to country. No, unilateral model law gives us an ample opportunity and also a good medium platform where we can communicate with different countries on the same level. And that advantage was there. I will not go into the details, the other aspects of reciprocity, non-reciprocity, etc. But let me only harp on two things on which we are looking for experience of the participants' countries. One is where international cooperation. Article 25 and 27 of the Unilateral Model Law provides for cooperation between courts and foreign representatives in the cross-border insolvent matters, which are referred in Article 1 of the Model Law. The Model Law does not specify any mode of communication. However, the Unilateral Guide to Enactment of Model Law, which deals with that problem, it is a guide to enactment, provides that the ability of courts to deal with appropriate involvement is lacking. To supplement the requirement of these articles, guidelines for communication and cooperation between courts in cross-border insolvent matters has been adopted by the Judicial Insolvency Network Conference of 2016, of which Singapore had been taking a leading role, which India were trying to follow. The guidelines had been adopted in England and Wales, being part of the guidelines Annex A, which relate to guidelines on conduct of joint hearings with courts of different jurisdictions. So these joint hearings, it serves as a platform for sustained and continuous engagement for furtherance of objectives to deal with cross-border insolvency. Now, the overarching aim of the GIN guidelines is the preservation of enterprise value and reduction of legal costs, and adds to the other sources of guidance about judicial cooperation by providing a framework. Now, EU also has a EU Judge Co platform, which provides another forum for valuable sources on cross-border insolvency, court-to-court cooperation and communication in EU context. The EU cross-border insolvency court-to-court cooperation principles cover 26 court-to-court cooperation principles, that is EU judge company principles, and 18 EU cross-border insolvency court-to-court communication guidelines. Now, this is one area which we are very much looking forward for the simple reason we have to have cooperation between bankruptcy tribunals, judges talking to other jurisdictions and trying to understand. So this is where we are looking for the experience of other countries, especially Europe, EU, and Singapore. And Jordan, I'm not sure whether they are doing that. We will be very happy to listen to their experience. The second area where we are looking for experience of other countries is that COMI, that is Center of Main Interest, where we expect a lot of litigation here for a simple reason, and this is a contentious area. The concept of a debtor's center of main interest is fundamental to the operation of model law. In practice, simultaneous application of the divergent and conflicting COMI tests opens the door to forum shopping and the jurisdictional conflicts, even in situations in which COMI of the same company is found in different states at the same time. The model law accords proceedings commence in all locations greater deference and more immediate automatic relief. So the essential attributes of debtor's center main of interest correspond to those attributes that will enable those who deal with the debtor, especially creditors, to ascertain the place where insolvency proceedings concerning the debtor is likely to commence. These are the two areas we are looking forward. I am very sure Unikrishnan will be able to develop this more because he's actually in the field and he knows better. I look forward to participants' experience and we are looking forward to hear from all of you. Thank you. Now, should we invite whom next, madam? Professor Laffy?
Advita ma'am, can you unmute yourself?
Sorry. Thank you, sir, for that insight into the insolvency and bankruptcy law and raising the area of concerns. I hope after today's we actually delved upon. Now, to begin with our session, first, I would love to introduce Professor Wee Meng Seng. He is Associate Professor at NUS, Deputy Director, E.W. Baker Center for Law, and Business Co-Director, Asian Law Institute. Professor Seng practiced law for a few years before joining EU as a senior tutor. He has obtained his BCL first class and DPhil from University of Oxford. His doctoral thesis is on contracts and corporate insolvency proceedings. In 2004, he served as a consultant to Statutory Board on a project involving issues of insolvency law. He is also an advocate and solicitor in Singapore and also backs various reputed publications. On that note, sir, I would request you to please address the session now.
Okay, good afternoon, everyone. Good afternoon, Dr. Viswanathan, Professor Biswa. Thank you for having me here today to present on Singapore's cross-border insolvency law. Okay, let me give you a short background to our adoption of the model law. You will see that there was we may say, a change in attitude between 2002 and 2013. Okay, because in 2002, the CRFC, a committee recommended that Singapore should wait and see. But by 2013, the IRRC recommended that Singapore should adopt the Ancitra model law without requiring reciprocity, and also to abolish the ring fencing of assets of a foreign company in liquidation. Now, I'll say a few words on ring fencing a few minutes later. Most of the recommendations of the IRRC. Now, at the same time, there was a related development in that the Committee to Strengthen Singapore as an International Centre for Debt Restructuring recommended further reforms to augment Singapore as a restructuring hub. Okay, so that was a related development. Now, the reforms recommended by the two committees, the IRRC and the one on making Singapore a restructuring hub, the recommendations were implemented in stages. The first stage was through the Companies Amendment Act 2017, which came into force on 23rd May 2017. Now, this piece of legislation was mainly concerned with reforms to Singapore's restructuring law and cross-border insolvency. This was the legislation that brought in the model law. That was followed by the second stage of the reform process, which was the enactment of the Insolvency, Restructuring and Dissolution Act 2018. Okay, or I will, for convenience, I'll refer to that as ERDA 2018. This act came into force on the 30th of July of this year. Now, this is a very important piece of legislation. It consolidated the 2017 amendments and bring within one statute, okay, for the first time in the Singapore's history, all the corporate insolvency proceedings, personal insolvency and bankruptcy, and cross-border insolvency law. Now, as I mentioned earlier, the IRRC recommended that Singapore should abolish ring fencing. Now, previously, the Singapore assets of a registered foreign company were ring-fenced to pay debts incurred in Singapore. Okay, I'll call that Singapore debts before remitter to a foreign liquidator. Now, please note, this is not about preferring Singaporeans or Singapore companies, but rather where debts were incurred in Singapore under the previous law. Okay, those debts enjoy, you may say, the assets will be ring-fenced to pay those debts. Now, the liquidation of foreign company, that is part of the doctrine of ancillary liquidation. Now, this is part of cross-border insolvency law, and this was developed by English judges in the 18th and 19th century. So, pursuant to the IRRC's recommendation, ring fencing was abolished by the Act of 2017. Now, but please note, the doctrine of ancillary liquidation still remains part of Singapore law. Now, I'll come back to this point later. Now, how did we abolish the ring fencing? Okay, we draw a distinction between relevant company and other companies. For a relevant company, the default position is Singapore debts will still be paid first before remitter. Now, relevant company here refers mainly to companies like in the banking sector, finance companies or trust companies. Now, for all the rest, okay, for all the other companies, the default position is the liquidator must, subject to payment of winding up expenses and preferential debts, remit the net proceeds to the foreign liquidator. Now, before doing that, the liquidator must be satisfied that the interests of creditors in Singapore are adequately protected. Now, I think we can see from this approach, the drawing of distinction between relevant company and all other companies, that Singapore has taken a step a more cooperative approach to corporate insolvency law. We say a modified, we have adopted modified universalism. Of course, the big show is the adoption of the model law. Now, the Amendment Act of 2017, like for example, the law in the US and the UK adopted the model law with minimal amendments to its text. Now, this means that, for example, the US and UK laws interpreting the model law, okay, are relevant to Singapore. Now, these are just, I mentioned these two jurisdictions just as example, just as an example. So, other jurisdictions that have adopted the model law with minimal amendments will equally be relevant to Singapore. Now, and I'll explain that again, I'll explain this point later. So now, under ERDA, sections 252 and 253 provide for the model law as set out in the third schedule to have the force of law in Singapore. So it is pursuant to these two sections and the third schedule that Singapore has adopted the model law. Further, Section 251 provides that Singapore insolvency law applies with such modifications as the context requires for the purpose of giving effect to the third schedule. Now, so this is to ensure that we marry together the model law and Singapore's insolvency law. Now, but as for the scope of the third schedule, okay, please note that unlike that in some other countries, for example, the UK and the US, the third schedule does not apply to individuals. It applies only to companies. Now, and the third schedule also does not apply in other situations. Okay, in certain other situations, for example, it does not apply to certain prescribed entities. For example, banks, finance, etc. Okay, because these are in very sensitive industries, and so we exclude them from the third schedule. Now, I think I will say a few words on the judicial attitude of the Singapore's judicial attitude towards the interpreting and the application of the third schedule. Because I think this illustrates how Singapore judges will do this in future as well. Now, I would argue that the approach has been innovative, pragmatic, and internationalist. Now, as Dr. Viswanathan mentioned earlier, now COMI is the most important concept in the model law. The adoption of the model law in Singapore has been the period has been rather short, a little short of 4 years. Okay, but cases have already come before the courts, and the courts have interpreted COMI. So I want to say a few words here, and I also want to mention the court's attitude towards the ancestral guides to interpretation. Now, the center of main interest, the COMI, was considered in two cases, Jetta Jet number 2 and Rooftop. Now, in both cases, the judge, Justice Adit, referred to law, EU law, Australian law, and US law. So the approach is very international. The judge adopts a very pragmatic approach in deciding which foreign law to follow. So, for example, with regards to the presumption of COMI, because under the model law, there's a presumption that COMI is in the company's registered address, the judge held that this presumption is not a legal presumption. Okay, it is only a starting point subject to displacement. So, in this regard, the judge preferred US law to EU law. But on the other hand, okay, insofar as taking into account the factors and giving the relevant and deciding on what weight to give to the factors in deciding where is the company's COMI, okay, the judge was influenced by EU law. So he held that when determining which factors to take into consideration, you need to ask how likely it is that a creditor would keep a particular factor in mind when deciding whether to afford credit to the debtor company. Okay, so he did not so although he followed US law in one aspect, but he followed EU law on another aspect, and you can see that also on another issue concerning COMI, which is the relevant time for determining COMI. Now there are three possible options. Okay, he considered the three options under EU law and English law on the one hand, US law, okay, and also Australian law. Now in the end, he decided to follow US law, and he gave some reasons for that. Now he was influenced by the courts. He was influenced by Singapore's attitude with regards to foreign shopping, which is that foreign shopping is not necessarily bad. Okay, debtors should be allowed to foreign shop for commercial reasons. Okay, but there are limits here. For example, evasion of criminal laws is not allowed. Okay, so he decided to follow US law. But although he decided to follow US law with regards to the timing for determining COMI, okay, he refused to follow the US law with regards to what are the kind of activities we can take into account for determining the COMI. So in the US case of Fairfield Century, the court held that liquidation activities and administrative functions, things which happen in the interim period between the commencement of the foreign proceedings and the application for recognition in Singapore, okay, the US court would held that you can take that into account, but the judge in Rooftop and Jatajat held that no, this thing should not be taken into account in the COMI analysis. So we can see from this that Singapore judges will choose selectively from foreign cases that the judge thinks are the most persuasive and appropriate in the application of the model law. Okay, now we can also see the attitude with regards to the NCTRA guides. Now, the third schedule provides that the preparatory papers and the 1997 NCTRA guide are relevant documents. Now, but please note that NCTRA issued a second guide in 2014, so there are two guides. Now, in Zeta Jet, the judge held that endorsement of the 1997 guide over the 2014 guide was deliberate. Nevertheless, the 2014 guide should not be entirely ignored. Consistency and comity should be pursued as far as possible in the interpretation of the model law. So where the 1997 guide is silent, okay, the court may consider the 2013 guide in the interpretation of the third schedule. Now, of course, this flexible approach will also help to ensure that Singapore follows the international trend. Now, continuing with this theme, okay, Article 8 in the third schedule, okay, provides that in interpreting the third schedule, regard is to be had to its international origin and the need to promote uniformity in its application and the observance of good faith. So in Jetta Jet, the court referred to this Article 8, and also there is a preamble to the third schedule which emphasizes cooperation and efficiency between the courts of states involved in cross-border insolvency. Now, the court held that Singapore courts should attempt to tack as closely as possible to the general interpretive trends taken in other jurisdictions that apply the model law in its various enactments. Okay, so we want to, as far as possible, follow the international trend. Now, I mentioned earlier, okay, that ancillary liquidation doctrine continues to apply. Now, this is, of course, part of the common law on cross-border insolvency. So, therefore, there's a vexed question of what is the relationship between the third schedule and the common law. Now, in the case of Rooftop, Justice Edith stated obiter that in general, where the model law is applicable to the subject matter, the court would be slow to allow common law recognition to be invoked as an alternative. Now, the main reason, according to him, is that the existence of a detailed recognition regime created by legislation displaces the need for common law doctrine to apply. Now, I think so far as the issue of recognition is concerned, there are good reasons for the court's approach. But of course, cross-border insolvency is not just about recognition, and recognition under the model law is actually rather preliminary, because relief may be discretionary, right? I mean, it doesn't necessarily follow up on recognition. So the relationship between the third schedule and the common law, this issue, right, will still await further development. Now, finally, as Dr. Viswanathan mentioned earlier, okay, there is quite apart from, or in addition to the model law, there is the judicial insolvency framework. Now, the Supreme Court of Singapore has been very active in promoting cooperation in cross-border insolvency, and in fact, it is a pioneer member of the JIN. The JIN has developed guidelines for court-to-court communication and cooperation, which will guide the preparation of protocols used in cross-border insolvency cases. Now, this is very helpful because it helps to give flesh to the broad principles on communication in the model law. Okay, I think I'll stop here. Thank you very much.
Thank you, Professor, for taking us through the Singapore insolvency law by way of various judgments. Thank you for the insight. Next, we have Professor Lafi Darak. Professor Lafi is Professor of Commercial Law at Yarmouk University. The area of research lies in commercial law, alternative dispute resolution, maritime law, information technology, and intellectual property laws. He has bagged various publications in many reputed journals and published a book on recognition and enforcement of foreign commercial arbitral awards. He also coaches and trains law students for local, regional, and international moot court competition. Professor, I would request you to kindly address the session. Thank you.
Thank you, Sharma, and thanks for the chair. Good afternoon, good evening, good morning for everyone. And I would like to thank the organizer of this round table to talk about a very important issue, which is the cross-border insolvency in different jurisdictions. And it is my great honor to be part in this round table to talk about the issue in Jordan. As insolvency issue or bankruptcy issue in Jordan, when we go back to the issue at the beginning, we have rules that govern insolvency in general, related back to 1966, which was part of the commercial law. We didn't have actually in the past rules or law only for insolvency. We had some rules or that governs insolvency as part of commercial law, and this exists for maybe 8 decades or more. According to the old rules, actually, that govern insolvency in Jordan, we have 3 stages for insolvency. The first stage is about the issuance of judgment regarding the insolvency issue when the debtor is unable or distressed to pay his debt. And we have here a competent court that has the jurisdiction to issue the decision on bankruptcy or insolvency. And there are a lot of proceedings here, and at the middle we have another stage which is maybe called reconciliation issue, where we may have a chance for the creditor and the debtors to have to reconcile their conflicts in a way or another, and to be adopted or accepted by the court at the end. Finally, if the reconciliation issue is failed, we will reach the final stage, which is the liquidation issue. Since 2018, we introduced a new insolvency law or bankruptcy law, and this new law replaced the old rules that govern insolvency in Jordan. And this one, the new one, actually is mainly influenced by the industrial model law on cross-border insolvency, regarding the rules that regulate the proceedings of insolvency in Jordan, or regarding the cross-border insolvency issue. We are still experiencing this new law, and we don't have that much of experience or cases that involved in this new proceedings. But a lot of challenge we are facing regarding the new insolvency law. The main challenge actually, which is about the proceedings, there are a lot of proceedings, complex proceedings. I mean, we didn't experience such proceeding before. The proceedings in the previous law were simple compared with the new insolvency law. In the new insolvency law, actually, we have many proceedings regarding the competent court, regarding the role of the debtors or the role of the debtors or their representative, and many different parts who can intervene in the process of insolvency. As I said before, we're still experiencing this in new law. We maybe face challenges, and by the time we may solve all these challenges. Even though we don't have that much of cases regarding insolvency in Jordan, we may have some cases, but maybe in the future we may have more insolvency cases before Jordanian court. As regard to the cross-border insolvency in this new law, actually, as I said, it's mainly influenced by the industrial model law in cross-border insolvency. It's like it was an easy job for the Jordanian legislator to copy these rules and to adopt it in Jordan as internal insolvency law in Jordan. And now we have insolvency, cross-border insolvency rules in Jordan, which were not available before in the previous law, and now foreign jurisdictions judgment can be recognized before the Jordanian court regarding insolvency. The rules that govern cross-border insolvency, according to the new law in Jordan, deals with the scope of its applications, the meaning of foreign proceedings differ between main proceeding and non-main proceedings. The proceedings can be commenced by the creditor or by the debtors or their representatives, and the ways by which we can recognize and enforce foreign proceedings issued by different foreign jurisdictions, and the kind of reliefs that can be sought before Jordanian competent court regarding cross-border insolvency. And it's mainly based recognition and enforcement of foreign insolvency procedures or proceedings depends on the reciprocal issue. I mean, if the foreign jurisdiction recognizes the Jordanian court decisions regarding cross insolvency, then the Jordanian court will also do the same, recognize the foreign judgment regarding insolvency issue. Yes, we have get benefit of the model law regarding cross-border insolvency in Jordan to have rules in Jordan that govern cross-border insolvency. It helps our legislator to introduce new rules regarding cross-border insolvency, and it is actually a new approach in Jordan regarding insolvency. Before, we don't have such rules that govern cross-border insolvency. And I think now we all experiencing the same crisis, COVID-19, and we didn't until now have any decisions from the government, as we now activating the defense law to deal with the COVID-19. We have many defense orders regulates different aspects of in terms of industry and different sectors in Jordan. We may have now, and we reached the Defense Act number 24, I think, but through all these orders, we don't until now have any rules that come across the cross-border insolvency issue. Hopefully, by the time in the future we can cope with these new cross-border insolvency rules, and the court can understand and get experienced on how to deal with these new rules that cover cross-border insolvency. And this is all that I can say about the experience of Jordan regarding the cross-border insolvency. Thank you very much.
Thank you, Professor. Thank you for giving that insight into the adoption of Jordan insolvency law and the challenges that are faced currently. And I believe mostly all countries are facing issues and difficulties due to the COVID situation. Thank you, sir.
Okay,
Next,
thank you.
we have Next, we have Professor Dr. Leon Trackman. Professor Trackman is a barrister and arbitrator specializing in commercial disputes. He has presided over 120 arbitration cases and number of NAFTA by appointment of US, Canadian, and Mexican government since its inception. Professor Trackman is also author of 10 books and over 120 journal articles. He is a former Dean of Law at University of New South Wales and currently a UNSW Professor of Law. He has had many reputed academic appointments and has received prestigious fellowship, including the Bora Laskin National Fellowship, a Killam Senior Fellowship, various grants awarded by Canada Council, the Social Science and Humanities Research Council of Canada. In 2018, he concluded a 4-year discovery grant awarded by Australian Research Council, for which he was lead chief investigator. Over to you, sir.
Thank you very much for those words, and I very much what I've heard. I've heard my clear. Okay, I'll just turn this up. I'd like to take you through a projected slide, and I'll just find it here.
So you have this share rights currently. Right beside your start video, there is a share option. You just click that and share your screen.
Okay, I have it here, but let me just, sorry, I'm a bit, one of the skills I don't have. Can you see the, I'm sorry, I'm just sitting with someone. Find it here. Yeah. Okay. Oh, I see right there. Okay. PowerPoint, right. Okay, my apologies. One slideshow. I've got a slideshow on. Okay. My apologies. It's been a long day and it's just after 10 o'clock at night. What I'd like to do is to take a slightly different approach. I particularly like the initial comments of the chair, and the reality is India is looking to adopt the model law, and I think that is a significant issue. And there's also the issue of countries like Australia that adopted it in 2008, Canada, I'm a dual national Canada as well. But there's a lot of effectively incomplete information about the operation, the functionality and the effect of the model law once it's incorporated into domestic law. So I must admit to having a certain amount of reservation about the model law in its present form. I do think it is a very significant step, but I think there is an argument that it should be extended further. And we just, two of us are writing a book on insolvency law, and we're actually pushing for a convention, I suppose not unlike the convention on the international sale of goods. And we feel that would give it more standing and more transnational significance. Now, whether that's realistic or not, one can debate, because you've got this inherent tension between the interests of states in terms of protecting their territorial sovereignty and the notion of surrender or sacrifice or cooperation or collaboration in order to develop and maintain common principles, such as around insolvency, and achieve efficient and for debtors and creditors. So I'm going to go through these slides selectively. There's too much, and then perhaps give you some comments. It is critical, but by the same token,
I'm so sorry to interrupt you, but your screen has not been shared. Can you just check it once?
okay.
Right beside your start video, there's an option to share your screen.
Okay, I thought I had done that. Just one second. Where do I do that? Just one second.
Yeah.
I'll go back to where I was. That? Okay. No. Okay. Okay, I'm going back to where I was.
Share screen.
Share screen, but it does say shared. So
Now open your
where?
now open your PowerPoint.
That's exactly what I did. Okay. Is that? Can you see it now?
No, sir, not yet.
Oh my goodness. I've done everything that I.
Slideshow.
One hit slideshow. There. That's not making any difference. I don't know how I can do this. I'm terribly sorry. I did follow the directions, and I've done this before. Just one sec. Okay, one sec. And then what now? Go to share. Okay. It's not. Why is it not doing that? No. Share. Share. No.
The actual share. Hit the actual share.
Can you see anything yet or not?
Yes, sir. Now it's visible, sir.
Okay. So,
I'm sorry, sir. You're not audible now.
Advaita ma'am, Ambika ma'am, I think Trackman sir has some bandwidth issue, so he wouldn't be able to share the PPT as well as his video. So we can make Ambika, can you make me the presenter right now? That will stop sharing the video for him, and then we can resolve this.
Yeah. Robert, sir, I have made you the panelist just now. If you are going to share the screen, maybe Prashant will not do that. Can you unmute yourself and
Yeah, good evening, and apologies. I did present earlier on. Leon, if you're there, I've come in to assist you, but unfortunately, too, just bear with us. We'll get this presentation on. Maybe if Leon can talk to it, and I will go through the slides. Okay. Yeah, no, I'm going to have the same problem in uploading and making available this slide presentation. It won't allow me to share. My apologies. Can I email it to somebody and they can upload it?
Yes,
Prashant,
I'm just
I
texting
add
you in
me.
the chat itself. My email ID. You can email it to me.
Right.
Prashant, I made you the presenter.
Yes, yes. Thank you.
Okay, that's emailed through now. I haven't put a heading on it. Are you still there, Leon?
Yes, sir, he is. He's there.
Well, maybe, yeah, if you can put it up, Leon can talk to it.
Yes, sir.
Yeah. Thank you.
So I think it's visible now.
It is. Is Leon there to talk to it, or would he like me to pick it up?
You can guide me through it, and I'll keep changing the video.
Okay, no worries. All right. Good evening, everybody. And Leon, if you're listening, just jump in and take over when need to. So Dr. Robert Walters is my name. I work very closely with Professor Leonard Drachman. We're currently 80% of the way through a book on cross-border insolvency. One of the questions that we've put forward is this notion of whether or not the UNCITRAL model law should be afforded convention status. And that's further explained in the book. But if you could go to the next slide, please. So as part of an introduction, and this is basically a lot of the work is taken directly from a chapter in our book. But when we talk about and think about cross-border insolvency, we all know that are present here this evening that regionalisation and globalisation of trade and investment and finance has resulted in companies no longer being confined to a single nation state. We know that, and that's been going on for now many, many decades. However, and even in a time of heightened deglobalisation and a stronger push for regionalisation and even countries looking inward again, we know that these cross-border issues are still alive, and they're not going to go away anytime soon. Furthermore, as we all are experiencing, some at a higher level than others, COVID-19 and its impact, particularly to the commercial and business world, and as many have pointed out today, the disruption to supply chains has been significant. Now, the number of insolvencies that are likely to fall out of that is also increasing, and a significant number is expected in 2021 through to 2022, depending on how economic factors actually alleviate and economies start to bounce back. It will be argued that the United Nations Commission on International Trade, UNCITRAL, should consider raising the UNCITRAL model law and cross-border insolvency to a convention status. So what we're arguing in our book is, apart from this, many other legal mechanisms that are used in cross-border insolvency and insolvency in general that sit at the national level should be raised to the international level, and most states, particularly common law states, which we look at India, the UK, the United States, Singapore, Australia, where we're located, certainly have some very common themes when you look at the legal tools and legal mechanisms that are available to assist in insolvency within the state, insolvency in a transnational context, but also, to take that one step further, some of these legal mechanisms that exist to assist companies to restructure and reorganise. So we're saying there that doing so would bring it in line with other international commercial laws, such as the CISG, and those who heard me earlier today talk about the CISG. Everybody knows that it has been very successful, even though the take-up on an international level isn't that wide in terms of the number of countries. Next slide, please. Leon, are you there? As we all know, UNCITRAL, or the United Nations General Assembly's endorsement of the model law was back in 1997. So just a little bit of background to lead us into the conclusion or concluding argument. UNCITRAL model law, CBI, aims to facilitate the administration of international insolvency cases involving the same debitor. In particular, aim to promote the orderly, effective, efficient and timely administration of insolvency proceedings, and the identification, preservation and maximisation of the value of the debitor's assets, including the debitor's business, on a global basis. The three key objectives that fall out of the CPI is to provide for an expedient and efficient and effective control of debitors' local assets, give the local court considerable discretion to grant various kinds of relief, and provide that this discretion is supported by a statutory mandate, i.e. included into the national framework, of which we've heard some cases that are already existing, and in particular the Singapore one and how they've dealt with it. Next slide, please. CBI comprises 32 articles and focuses on access of foreign representatives and creditors to courts in the enacting state, recognition of a foreign proceeding and relief, cooperation with foreign courts and foreign representatives, and for concurrent proceedings. Chapters 1 and 2 focus on foreign representatives in having the right of access to the domestic courts in each state, engaged in concurrent proceedings. Without conceding jurisdiction to the courts of those states, the model law proposes that they have the right to participate in domestic insolvency proceedings. And furthermore, were the model law to have denied such access transnationally, the parties would be inhibited from resolving insolvency issues expeditiously, and that's in accordance with Article 14. Moving on to the next slide, please. In continuing with Chapter 1 and 2, Article 5 authorises the person or body administering a reorganisation or liquidation under the law of the enacting state to act in a foreign state in furtherance of local proceedings. And furthermore, in terms of inbound requests, a foreign representative applying for access and participation in proceedings in the enacting state has the following rights. And one is of direct access to the courts of the enacting state, and two, to apply to commence a local proceeding in the enacting state, subject to the legal conditions applicable in that state, and three, to apply the recognition of the foreign proceedings in which they were appointed to represent. Therefore, upon recognition, a foreign representative is entitled to participate in insolvency-related proceedings conducted in the enacting state under the law of that state. Those access and related rights do not subject the foreign representative or the foreign assets and affairs of the debitor to the jurisdiction of the enacting state for any purpose other than that application. Next slide, please. Furthermore, when we move forward to Articles 13 and 14, they provide the foreign creditors the equal rights to domestic creditors before domestic courts. This terminology reflects the language used in Article 5 of the model law and is used for consistency with the UNCITRAL legislative guide on insolvency law. This explains that the insolvency representative is a person or body, including one appointed on an interim basis, authorised in insolvency proceedings to administer the reorganisation or liquidation of the insolvency estate. Next slide, please. Article 15 underpins, so we've moved now to Chapter 3. Article 15 underpins the justification for the development of the model law. It plays an important role in harmonising the national laws in the application for recognition of foreign proceeding. Fundamentally important, and one could argue it has very much similarities to contract law. In recognition of foreign proceeding, Article 17 encourages states to implement provisions within their national laws directed at acceptance of foreign proceedings in accordance with the 2018 UNCITRAL model law on the recognition of foreign judgments. However, incorporating such a provision into domestic law of signatory states would not prevent modification or termination of recognition of foreign judgments if it is shown that the requisite grounds for granting enforcement were fully or partially lacking or have ceased to exist. Next slide, please. Furthermore, a further note of caution is required whereby the model law is not intended to accord recognition to all foreign insolvency proceedings. That is, subject to Article 6, Article 17 specifies that the court should recognise the foreign proceeding, and that is the optimal word there is should recognise the foreign proceeding without further requirement. Once the requisites specified in Article 2 concerning the nature of the foreign proceeding are met. These requirements include provision for collective proceedings, participation of the foreign representative and that evidence required by Article 15 as being provided. These requirements are that the foreign proceeding is as a matter of course, a collective proceeding for the purposes of liquidation or reorganisation under the control or supervision of the court, which is an important point because what it's saying here is you've got that court oversight. When you start to look at those other national mechanisms, which I'm not going to go into here because it's too expansive, but one comes to mind is schemes of arrangement that are used under Australian national laws, and they exist elsewhere in other common law jurisdictions. The court has supervision over them. And next slide, please. Furthermore, the process of application and recognition of foreign proceedings is aided by the presumption contained in Article 16 that enables the court in the enacting state to presume the authenticity and validity of the certificates and documents originating in the foreign state that are required by Article 15. In addition, Articles 19 and 20 underpin the need for the recognition and application of foreign proceedings and judgments. Furthermore, Article 19 also authorises the court in the enacting state to grant the type of relief that is usually available only in collective insolvency proceedings, i.e. relief available in accordance with Article 21, as opposed to individual relief that may be granted before the commencement of insolvency proceedings under the rule of civil procedure. However, it must be noted that the discretionary collective relief under Article 19 is somewhat narrower in scope than the relief that's been afforded under Article 21. Next slide, please. Furthermore, Articles 20 and 21 encourage states to recognise a foreign main proceeding and that any relief provided is to be granted upon recognition of the foreign proceeding, while Article 22 undertakes to ensure the protection provided to creditors and other interested persons. Furthermore, Article 23 promotes the idea that actions be not taken to avoid acts that are detrimental to the creditors, a protection mechanism, for want of a better word, and control mechanism to protect the creditors. And many national laws actually go down that road in having specific provisions and legal mechanisms in place to assist and protect creditors. Thus, the intervention by a foreign representative in insolvency proceedings can be undertaken where the debtor is the party. Next slide, please. Chapters 4 and 5, which basically bring us to the conclusion. Another important feature of the universalist approach to cross-border insolvency can be found in the following articles, Articles 25 through to 27. Allows for cooperation and communication between foreign courts and foreign representatives. Now, Leon, are you there? No? I was going to allow you to pick up the conclusion here. Article 25 to 27 can be considered central provisions of the model law. Why? Because they strengthen cross-border approaches to cooperation. Without that cooperation, international borders, particularly the facilitation between the courts, it would not be effective. The recognition of foreign made proceedings does not prevent commencement of local proceedings in the enacting state, nor does the commencement of local proceedings in that state terminate recognition already accorded to foreign proceedings or prevent recognition of foreign proceedings in accordance with Article 28. Furthermore, Article 29 assists in addressing the adjustment in the relief available where there are concurrent proceedings. That is, the basic principle is that for, sorry, I'll start that again. The basic principle is that under Article 29, for relief to be granted or to be recognised for foreign proceeding, it should be consistent with the relief granted in the local proceeding. Next slide, please. Articles 31 and 32 also concentrate on reconciling and encouraging greater coordination in the recognition of foreign insolvency proceedings, and that is that Article 31 establishes a presumption that the recognition of foreign proceedings is proof that the debitor is insolvent, where insolvency is required for commencement of a local proceeding. And furthermore, Article 32 is precautionary in nature. What that does is it establishes a rule to avoid situations in which a creditor might make claims and be paid in multiple insolvency proceedings in different jurisdictions, thereby potentially obtaining more favourable treatment than other creditors. And that concludes us. Next slide, please. Yeah, so that concludes us with the specific articles there, and just to go into that detail is important because it brings us to why we're arguing for it, or really posing the question, and posing the question to everyone that's present here today, and furthermore to UNCITRAL, right? That the CBI can be summarised as providing a procedural structure, creating a cross-border system, and not merely a set of international standards. And I think most here would agree with that. It is effective. Does it cover everything off? Well, we all know that it doesn't. It falls short in some areas. Can it be improved? Of course it can. But can the CISG be improved? Absolutely. No law is. However, significant gaps remain in harmonising and particularly getting legal cross-border or transnational convergence in cross-border insolvencies. Why we're arguing and posing that question, raise it to the convention status, is on that point, is that nation state, by signing up to a convention and ratifying that convention, while many don't, those that do further include those provisions and make way for them at national law level and give them higher priority. And by the way, I say that in the context of not downplaying what a model law or this model law's role is. It does not expressly address choice of law issues, and that is a major gap. And those of us who practice in this area, in private international law areas or arbitration, as Leon does, and I'm doing in the future, and only implied considers outbound insolvency issues through rules on international jurisdiction. That needs to be addressed. One way to address it, in our view, is to make it a convention. Addressing these gaps through a convention on insolvency law, extended model law rules and judicial determinations can make the transnational insolvency regime more complete and less prone to territorial bias. And that is one of the issues that's falling out even through COVID, that you can start to see that territorial bias creep in. And it's evident, and that's a natural course of events when we talk about transnational issues. It may also help to streamline insolvency proceedings, and that's what we argue overall in the book when we look at other areas such as letters of comfort, schemes of arrangement, and particularly closeout netting provisions, right? Such as to facilitate enforcement by removing excessive territorial protections and ensuring general consistencies in proceedings across jurisdictions. And there's no better example than that than the CISG and the UniDroit principles, the UniDroit principles that underpin the CISG. Next slide, please. Or is that the last one? So in conclusion, there are a number of highly successful UNCITRAL model laws that we've all discussed and know about. CISG is one. While not every state has adopted the CISG, it has been applauded. And I note that Luca Castellani was present earlier today, and he's been a big advocate for it and written about it very well. And so forth. While not every state has adopted the CISG, it has been applauded transnationally for the framework that it's enabled in international trade law. its carefully balanced systems of contractual remedies and has crossed the common law and civil law divide and assisted exponentially, and I use that word carefully, but it has exponentially assisted countries that otherwise would not have signed up to it. And I think that just about concludes us there. So just as a concluding remark, look out for our book next year, Contemporary Issues in Cross-Border Insolvency. It'll come out in about 12 months' time. And thank you very much to Professor Trackman for the work I do with him over the last 5 years. And thank you for Gia and you.
Thank you, Professor Leon and Robert Walters, for that detailed information on the cross-border insolvency law in Australia. And apologies for the technical glitches, because of which we couldn't hear more from Professor Leon. Also, if I may request Professor Robert Walters to share the details of your books, if it is possible for you.
Yes, I will through Professor Biswell, if I may.
Yes, sir.
Yeah.
Sure, sir. Sure.
Thank you.
Thank you. Thank you. Next, we have Professor Stephanie Roffling. Professor Stephanie is a holder of PhD in German law at the Johann Wolfgang Goethe University. Apologies for my pronunciation, Professor Stephanie. And she's also PhD in French private law at University Paris, Sorbonne. She is full professor at University Paris Nanterre since 2008. She is in charge of German law curriculum and the German-French Doctorate College between the universities of Paris Nanterre and Potsdam. She regularly teaches German private law at University Paris Nanterre. Again, I apologize for my pronunciation. And
so, yes, thank you very much. Do you hear me?
Yes, ma'am.
Yes.
Okay, perfect. And do you see, I try to share my screen with my PowerPoint. Do you see the PowerPoint or not?
Yes. I can see it.
You can see it? Oh, that's perfect, because with all those technical problems, we never know if it works. So first of all, thank you very much to all the team of the GNLU for organizing this conference and for inviting me, especially to Professor Mamata Biswal. So I'm very happy to see you again on this conference, even if it's only virtual way to see us, but it's anyway, it's good to see you, and I hope that I can come back to the GNLU very soon on next year. So really, thank you very much. I'm very happy to participate here. So I will. Thank you also for the presentation of myself. I'm actually lawyer and a law professor in France, and I studied also in Germany. So I'm of German origin, so I can treat both countries. But my presentation is today more on French law, even if a lot of this, what I will tell you, is also applicable to Germany, because we are all in the European Union. So it is mainly also European Union law. And I think my colleague from Italy is not with us today. So maybe it is the only presentation also on European Union law. I will try to be very short, because I learned in the schedule that I have only, I think, 10 or 12 minutes to speak. So I will, just talk about the basic principles, because otherwise it would be really so very long. So it is on cross-border insolvency in France, and we have two cases. So the cross-border insolvency can be inside or outside of the European Union. So this cross-border insolvency in France, the first question was if France has adopted the UNCITRAL model law and definitely they have not. And in Europe, very few countries only adopted this model law. In Europe, it's only 3 countries, so Greece, Poland, Romania. All the 3 countries are more, kind of small countries in Europe that have not so much economic power. So we can say the main countries like Germany, France, Spain, Italy, they didn't adopt this model law. And most of the highly developed countries that implemented the model law are common law countries. So I did for myself this reflection to say, okay, it is United Kingdom, United States, Canada, Australia, but all these very important and economically very developed countries are all common law countries. I don't know the reason why only very developed common law countries adopt the only CISG model law and not countries from continental law. But there should be a reason. I didn't make a study around this question, but I think there should be a reason of the distinction of common law and continental law. So for the prevailing law in France, as we can't apply the principles of the model law, we have to distinguish a cross-border insolvency interior of the European Union or with countries outside of the European Union. Firstly, I will speak about the cross-border insolvency between European Union member states. So there we have a regulation from the 20 May 2015. And these rules are only so for the insolvency, but only cross-border insolvency. So it is not applicable if the insolvency is only in France or only in Germany, only in one country. Yeah? So for this cross-border insolvency, we have some rules in the regulation. So if the debtor has the center of his principal interest in a member state of the European Union, the regulation will be applied. The regulation applies not only to classical insolvency procedures, but also to temporary or amicable procedures. So currently in France, it covers also the procedures of receivership, judicial liquidation, and safeguard procedures. Over indebtedness procedures for private individuals are not covered by the procedure of the regulation. So the structure of the procedure under European Union law is, first we had bilateral treaties, but all these bilateral treaties were replaced by regulation of 2015. And also we have several directives on insolvency law, but this is only for harmonizing the law, the national law in the different member states. Huh? But they are not applicable on cross-border insolvency. The regulation on cross-border insolvency organizes a main insolvency procedure according to the principle of universality. The main insolvency procedure is recognized automatically in all the member states. There is still a possibility of a secondary insolvency procedure in another member state, but the secondary procedure is strictly territorial and is dependent on the main proceedings in the place where the main interest of the debtor. The forum consensus is therefore split between main and secondary insolvency procedure with several openings of insolvency proceedings. So we can have one main and several secondary procedures in other member states. But both, as all the procedures, are managed in close cooperation. So I have here in the slide, you can find the opposite of the principle of universality and the principle of territoriality. So for the main procedure, we apply the principle of universality. So all assets of the debtor are affected by the insolvency without any exception. All creditors are treated in the same way. The insolvency principle in the European Union regulation for main insolvency is this principle of universality. Member states must recognize and respect all decisions. Oh, sorry, I went too far. All decisions of the main procedure. The principle of territoriality is only applicable for secondary procedures. So if the insolvency if the debtor has assets in several countries where creditors can be satisfied, but they are limited to this secondary procedure located in their country. So they can't come to other assets in another country. So here we have the principle of territoriality. The principle of secondary insolvency proceeding in member states applies the principle of territoriality. That means that we have limited effects only on assets located in the country of the secondary proceeding. But all all procedures are dependent from the main procedure. Now I will talk a bit of insolvency, cross-border insolvency procedures, but in international ways, so out of the application of the regulation of the European Union. So if it is with a third country that is not a member state of the European Union, and with interests of the debtor in France. So the international competency for opening of an insolvency procedure in France is first the autonomous interpretation of the principal procedure by the local court. For physical persons, the place of the main residence or habitual residence will determine the competency of the court, so the place. And for companies, there's a presumption for the registered office, so the proceedings will be opened at the place where the company has its registered office. The international competency of French courts for opening an insolvency procedure in France, if the debtor does not have a center of its main interest in a European Union member state, French law gives the French jurisdiction the possibility to open insolvency proceedings at the place of the debtor's registered offices. If the debtor does not have a registered office in France, it is a place where he has its main interests in France. The effect of insolvency proceedings opened in France are universal. So in order to implement this principle of universality in the international legal order, an exequatur is usually required. The same applies in the opposite direction. So here we have no facilitation of the procedure. We will simply apply the principle of international private law for the place, find the competency and to find the place where to open the procedure. And for all decisions, we need the exequatur, like in every other international affair. The governing law follows the jurisdiction. So if the French courts have the competency to opening insolvency procedures, the governing law will be French law. The lex concursus is the law of the state where the proceedings are initiated. So in my example, it is French law. But there are some exceptions for the governing law. For example, the lex restituere remains applicable for real collaterals in property located in another country. So we can have also, it's the same case, application of French law and another law. So to conclude, just a very short indication of the impact of the COVID-19 pandemic. So in France, like in nearly all other countries of the European Union, the government took different measures to try to limit bankruptcy and job losses in this health crisis. In France, there is a bylaw of 27 March 2020 that has put in and adapted the rules relating to difficulties of companies in the context of the health emergency. So the measures are, there are a lot of measures. I could talk 1 hour only about the special measures. But just to talk about the principal ones, is that the fixing date of the cessation of payments. The assessment of the state of cessation of payments is still carried out with regard to the situation as of March 12, 2020, so before the pandemic, before the health crisis. So the state will have a look on the financial situation of the company before the health crisis and all the problems during the lockdown will not be taken account for the determination of the bankruptcy or of the insolvency. So only companies that have already financial problems and cessation of payments before the health crisis will have now the insolvency procedure. The other, for instance, they will wait to see how it will go on in 2021. So these measures are, for instance, applicable up to and including December 31, 2020. So it is in 1 or 2 weeks it will be finished. But I think there's a chance that they will continue to apply this measure. So there will be another bylaw for prolongation because until now the health crisis is unfortunately not over. And in Germany, we have the same. So the impact of the COVID-19 pandemic is very important. And when you see today in Germany, we have a very, very few insolvency procedures, less than at the same time in 2019, because they are all waiting. And the measure in Germany was that during the health crisis, companies are not obliged to open insolvency procedure. They can wait until after the health crisis. So that's the reason, because we have less insolvency procedures now than in the preceding years. So that was a very short overview over the procedure of cross-border insolvency in France and over the impact of the COVID-19 pandemic on this insolvency procedure. Thank you very much, and thank you for your attention.
Thank
I
you,
hope
Professor.
it was not too fast, but
Not at all, ma'am. Thank you. Thank you for the beautifully summarizing the position of cross-border insolvency law in France and EU both. Thank you, ma'am.
Thank you.
Next, I would like to invite Dr. Rajendra Prasad Gunput. He is holder of 2 PhDs in law. He is currently an associate professor of law at University of Mauritius. He has been the head of law department multiple times during his career. He is the honorary professor of a university of Xiantan in China. He is editor-in-chief of Just Africa Journal, Polokwane, South Africa. He is also a member of National Coordination Committee on Issue of Human Rights and a member of the Environmental and Land Use Appellate Tribunal. I would request Dr. Rajendra Prasad to kindly address the session.
Good afternoon to everybody. Do you hear me?
Yes, sir.
Good afternoon. I would like to thank Professor Mamta Biswal for inviting me for this roundtable to talk about situation in Mauritius, on cross-border insolvency. I have just prepared and sent some slides so that you can follow how we are tackling UNCITRAL model in small island state of Mauritius. So without much ado, let us move to the next slide, please. I will talk on the Mauritian perspectives. Next slide, please. Of course, the cross-border, I will answer to some of your questions about cross-border insolvency issues in Mauritius. Whether we have adopted the new UNCITRAL model law? Yes, we have done it. So far, have they incorporated in the model law in their domestic law? Yeah. Again, once more, it is made statutory. Is it efficacious, successful? Yes, to some extent. And the impact of COVID-19 pandemic, because at that time, during March, April, May, June, mid of June, everything was locked down in Mauritius, just like most countries of the world. Next slide, please. Domestic legislations. Yes, UNCITRAL model has been domesticated in our law in the form of International Arbitration Act 2008, Act 37 of 2008. There is a convention on the recognition and enforcement of foreign arbitral awards Act 2001, and the investment dispute enforcement of awards of 1969. Of course, as one of the presenters explained, we have a mixed system with English common law and French civil law. We have inherited both systems, and in Mauritius, you have also the Code de Procédure Civile and Code de Commerce Mauricien. And Code de Commerce Mauricien, the Mauritius Commercial Code, in some way, we have signed and ratified most treaties and conventions, and they have been implemented in that code. However, next slide, please. On the United Conventions on Contract for the International Sales of Goods, it is an important reference in international trade law as such. But in Mauritius, it is still not applicable to the Mauritius context, as Mauritius is not a signatory to that treaty. In the international context, there is more in Mauritius a tendency to adhere to the ICO terms issued by the International Chamber of Commerce. And some of these terms are recognized in our Code de Commerce as explained. Therefore, actually, we are relying more on common law, on English precedents as such, so that in case there are doubts as to interpretation, we'll follow the English precedents and common law. Next slide, please. As explained, Mauritius has signed and is a signatory of the New York Convention and of the Washington Convention. Mauritius has signed the convention on 19th June 1996 and acceded to the convention on 17th September 1996. I explained somewhere, and one of the presenters did it. We are still following French international private law. As Professor Dijou explained, in case there are doubts, your explanation, which tribunal, which court is competent against, we are relying on French international private law. This is because we, at that time, we were under colonial law and the French colonization. This being explained, Mauritius has also signed the convention on 2nd June 1969 and acceded to the convention on 2nd July 1969. Next slide, please. Now on reciprocity, the legal system of Mauritius being a hybrid system with English common law as explained, French law, because we have still actually, despite Section 1 of the Constitution provides that Mauritius is a sovereign state, we are still under colonial law. Our civil law is still based on the Code Napoleon, the Napoleon Code, except there have been some little amendments here and there, but still the old penal code, French old penal code, is still applicable in Mauritius. Therefore, we have a mixed system, but our Mauritian legislator still borrowed a lot of legislations from other countries. I will come back to that. For example, our company law, for a very long time, it was based on the English common law, and actually, most of relevant sections of the English common company law have been removed and replaced actually by the New Zealand Company Act 1995. Similarly, when there are issues related to fraud and corruptions about the double taxation avoidance agreement, investment law, we still refer to Prevention of Corruption Act and Prevention of Terrorism, two legislations which have been borrowed from Singapore and Hong Kong, respectively. Therefore, these two conventions were transposed into our domestic law. The first through Act 2001, the Convention on the Recognition and Enforcement of Foreign Arbitral Award 2001, and the second one through Act number 12 on 1969, the Investment Dispute Enforcement of Awards Act. The accession of Mauritius to the New York Convention was made subject to the reservation of reciprocity, but not of commerciality. This being said, the next slide, please. Now, concerning Insolvency Act, the Companies Act 2001, which is a good mixture of English law and New Zealand law. Actually, we are following cases from England, common law, and we are also following precedents from New Zealand because we have borrowed the New Zealand Act. And the Insolvency Act 2009, these two legislations are the principles law governing the restructurings, reorganization, liquidations, insolvencies of companies generally in Mauritius. So let us move to the next slide, please. Thank you. The Insolvency Act 2009, especially Part 6 of the Insolvency Act 2009 of the Republic of Mauritius, is based principally on the 1997 United Nations Commissions on International Trade Law, UNCITRAL, Part 6, on cross-border insolvency, and regulates cross-border insolvency proceedings, the model law, coupled with a country which has inherited French civil law during the period 1715-1820 and the UK common law between 1810 to 1968, where on the 12th March 1968 we got independence and became a republic on the 12th March 1992. Therefore, we got two successive colonization, French and British colonization. And apart from the arbitration agreement, there is also French law, the compromis, which is applicable both in domestic and public international law. In our domestic law, the Code de Procédure Civile, the Code of Procedure, in its article 1008 to 1010 provides for a compromise between parties to a dispute. How it is applicable when UNCITRAL law is in issue? Article 1008 of that Code of Civil Procedure provides that the compromis is a convention between parties to a dispute and may have resort to arbitration between one of the two parties, and still they can go to the Supreme Court, and the Supreme Court would decide whether our arbitration and foreign awards are admitted or accepted in our jurisdiction. In arbitral awards, for example, it is a common practice in Mauritius that the losing party usually rely on public policy and just ask the court to set aside the award because it is not enforceable in that country as the award is against public policy. In fact, Article 1026 to 9 alinéa of the Code de Commerce, a Code de Procédure Civile, provides that even the Ministère Public, the minister, may oppose to the execution execution of an arbitral sentence, if provided it is against public policy, l'intérêt public. So we have a mixed system with English law, French law, and all these conventions, covenants, municipal model, which have been implemented in our legislations and form part of our domestic law. Next slide, please. I explained we have a Code de procédure civile, which explains that there are relevant issues on compromise. Even in labor dispute also, you may have recourse to arbitration. This is being explained. Let us move to the next slide. Here, now you have the International Arbitration Act on one side, and on the other side, you have the institutional model. So you can follow the articles. It's almost the same. Article 2, Article 3, 4, 5, 6, 7, they are compatible with the institutional model law, It's the same sections, but with maybe Article 2 may become Article 3 and so forth and so on. But it's the same. A good copy of the institutional model. Let us move to the next slide, please. So what about the situation in Mauritius during confinement and deconfinement? The government passed the COVID-19 Miscellaneous Provision Act 2019 to make the small island state a COVID-safe free country and to give a level blow against the pandemic disease. In Mauritius, with its 1.3 million inhabitants, we recorded very, very few cases because with lockdown, everywhere was closed, everywhere. And people just have to work at home, and we had lectures like in so many countries. There's nothing new in it, with lectures using Cisco Weber events, using Zoom, and so forth and so forth. Now, if we have some very few cases, the government passed the Quarantine Act, but there is nothing new in it against. It is also colonial law 1954, but a new Quarantine Bill 2020 was passed to amend the Quarantine Act 1954 to impose new terms of imprisonment, 5 years imprisonment, if you don't wear a mask, for example. If you are circulating during confinement, it's a big sum of money, 500,000 rupees, for example. And citizens were not allowed to circulate during the months of March, April, May, until nearly end of June. There were a lot of restrictions so that the COVID-19 would not, people won't be affected by that pandemic disease. So these are two important laws. Only the COVID-19 Miscellaneous Provisions Act 2019 is a bulky legislation which revises more or less all the legislations in Mauritius on the Labor Act, on the Employment Rights Act, on the Employment Relations Act, on the Employment Relations Amendment Act, and the new Workers' Rights Act. It's amend most of them that now people during confinement won't be able to go to work unless you are provided in Mauritius. I don't know situation in other countries. You may have access to work provided you have a working access permit delivered by the university, by your employer, and approved by the Commissioner of Police, so that you can circulate freely in Mauritius. It's very rare to have your WAP, your working access permit, but it was to some extent feasible to some people who have to attend their workplace during confinement. But in Mauritius, actually, confinement is over. Some people wear masks, and there are some restriction in bus. You have to wear your face mask, etc., etc. So this is the situation in Mauritius with the municipal model, which is made statutory. It is a piece of legislation in the form of the International Arbitration Act, and recently it has been amended with some new provisions. So here we are. I would like to thank you for your attention.
Thank you very much, sir. Thank you for that detailed and technical information of Mauritian law, and particularly the details of law prevalent during pandemic. Thanks a lot, sir. Next, I would invite Sri Methli Unnikrishnan to share his views on the theme. I would just like to introduce him. He's serving as a deputy legal advisor at Reserve Bank of India. He has previously worked as general manager at Insolvency and Bankruptcy Board of India. He is also part of high-level committee for recommending rules and regulatory framework for smooth implementation of the proposed cross-border insolvency provisions in the IBC, the Insolvency Code 2016. Over to you, sir.
Thank you, Advaita. To upload my presentation, please.
Yes, sir. Prashant?
Very good evening to all the distinguished panelists, respected chair, Madam Biswal, and all the other attendees. It is indeed my pleasure to be part of this gathering today and convey the position insofar as the cross-border insolvency related developments in India are concerned. So I'm indeed grateful to GNLU and IBBI for giving me an opportunity to be part of this roundtable.
Just a second, sir.
Thank you so much. So just to give, next slide please, just to give an background, of course the chair has given an introduction about the Insolvency and Bankruptcy Code, which is one of the milestones insofar as economic legislations are concerned. And in 2016, we consolidated and codified the insolvency laws in India into this legislation, which is the Insolvency and Bankruptcy Code. Even with the enactment of this Insolvency and Bankruptcy Code, we don't have a very comprehensive framework for cross-border insolvency. As Chair was indicating as part of his introductory remarks, there are only two sections which are available as of now under the code, which are provided under sections 234 and 235. These sections essentially rely upon bilateral agreements which the central government would enter into with other reciprocating territories. And based on those bilateral agreements, whenever there are assets or evidence required in other jurisdictions in relation to an insolvency proceedings, the adjudicating authority in India, which is the National Company Law Tribunal, could issue a letter of request to such countries. So this is all what we have insofar as the cross-border element in the Insolvency and Bankruptcy Code as of now. Now, this raises some fundamental practical issues. And apart from this, we also have certain limitations insofar as the enforcement of foreign judgments are concerned, particularly in the context of interim orders or administrative orders or insolvency orders are concerned. Because the civil procedure code, which governs the civil procedure relating to the courts, the definition of foreign judgments do not include these kinds of administrative orders. And we don't have an explicit provision to deal with the matters of recognition of foreign proceedings. And fundamentally, even the civil procedure code provisions are embedded with the requirements of a reciprocating jurisdiction. So we have certain limitations under the general civil procedure as well as under the insolvency framework. Now, as a consequence, the treatment of Indian proceedings and judgments abroad, as we all know, in the absence of a model law, is also dependent on the law of the country in which it would apply. Next slide, please. So in this background, the drawbacks, what we could very clearly make out from the current legal framework is the fact that there would be a need for long-term negotiations. And even with those negotiations, it may be difficult to achieve uniformity in the bilateral agreements with different jurisdictions. Now, even with bilateral agreements, when they are having with multiple countries, there could be procedural complexities when, when a corporate debtor has assets in multiple jurisdictions, and we need to handle an insolvency process involving all these multiple agreements. So there is absolutely, difficulties for lack of guidance if there is, no bilateral agreement with the country also where certain assets may be situated. So under the current mechanism, under the Code of Civil Procedure, as I mentioned, there are difficulties for enforcement. So there is some element of lack of clarity in the procedure and predictability, which could pose a concern for the foreign creditors, particularly when they do a kind of a trade in relations. Next slide, please. So this was very much there in the minds of the draftsmen when we introduced the Insolvency and Bankruptcy Code, and being a very new law and to take care of the market requirements, the Government of India had constituted a committee, which is the Insolvency Law Committee, which is a permanent standing committee to make recommendations for improvements in the legislation. So in the very first report of the Insolvency Law Committee, which came out in March 2018 itself, the committee recognized the fact that there is a need for a comprehensive framework adopting the UNCITRAL model law as part of the framework available under the Insolvency and Bankruptcy Code. But first report, this being a very complex subject, did not delve with the matter. Next slide, please. And this came out as part of the recommendations of the committee in October 2018. Now, this report of the Insolvency Law Committee, which was exclusively on the cross-border insolvency aspect, examined the UNCITRAL model law very in detail and came out with the recommendation for its adoption with certain modifications. Of course, the modifications are minor, whereas substantial provisions of the model law have been recommended to be adopted. So these are all in the recommendation stage, but certainly at a very advanced stage. Now, as part of the minor deviations, the provisions recommended by the Insolvency Law Committee requires a reciprocity. But of course, the committee has recommended specifically that this reciprocity is being recommended only for and the initial phase of its implementation, and this to be diluted as and when the system settles down and the jurisprudence develops. There are few other minor deviations as well, where the direct access for a representative will also be subject to certain regulations. But broadly, when we look at the terms and conditions which have been laid down in the report, we find that the substantial provisions of the model law are proposed to be adopted, or rather almost the entire model law is proposed to be adopted with certain rules to be laid down for a smooth implementation aspect. Now, these amendments are yet to be enacted, but the broad framework, including the chapter to be incorporated in the insolvency code, has been drafted, and that's part of the report which is already submitted to the government. Now, next slide, please. When we look at the applicability of the model law, what we can very well make out is that this would very clearly be advantageous, and it would come to the forefront under 4 scenarios. One, of course, when you are seeking assistance in India by a foreign court or foreign insolvency professional in connection with the foreign proceeding, or where an assistance is sought in foreign country regarding a proceedings happening in India. Similarly, there could be parallel proceedings, concurrent proceedings happening both in a foreign jurisdiction and a domestic jurisdiction, or where a foreign creditors or interested party wants to commence a domestic insolvency proceeding. So all these 4 scenarios highlight the relevance and importance of a model law adoption insofar as making it part of an insolvency framework. Next slide, please. Taking cue from this and recognizing this importance, the Insolvency Law Committee specifically recognized the 4 broad principles which the model law propagates. And those 4 principles have been incorporated as part of their recommendations. First, dealing with the access of representatives, both a domestic insolvency professional in India participating in a proceeding in a foreign country, and a foreign representative applying for recognition, cooperation, or coordination in a proceeding in India. So this recommendation is this would be subject to certain regulations which governs the insolvency professionals practice. The other second aspect which has been recommended is relating to the recognition of foreign proceedings. As I mentioned, there is no explicit powers and provisions as of now available. So the committee has recommended for making application by foreign representative for recognition in India in the manner prescribed, because that will lay down the rules for the applications to be submitted to the NCLT. And completely adopting the provisions of model law, the provisions of recognition depending on whether the proceedings is a main proceeding or a non-main proceeding based on the definition of COMI, which has been completely adopted. The reliefs which are provided under the model law have also been incorporated into the framework which has been suggested. The third and fourth principles deals with cooperation and coordination, which have also been elaborately adopted as recommended by the committee. The public policy exemption, which is also provided under the model law as a ground for refusal to grant recognition, has also been proposed as it is, which says that if it is only opposed, manifestly opposed to the public policy. So the committee, Insolvency Law Committee, has broadly made all these recommendations, but the fact remains that this requires some sort of delegated legislations to be put in place to enable its smooth implementation. So next slide, please. So this necessitated the creation of another committee by the Government of India, Ministry of Corporate Affairs. And this committee was specifically tasked with the responsibility of drafting the framework for the subordinate legislations for giving effect to the cross-border insolvency framework recommended by the Insolvency Law Committee. Now, this second CBARC, the second committee constituted by the government, of which I happen to be a member, has also submitted its report to the government containing the first draft of the subordinate legislations which needs to be put in place. So this clearly highlights the fact that the arrangements and the preparation towards the laying down a framework for a cross-border insolvency adoption is much at a high prepared stage, and it's under consideration. In the meantime, next slide, please. In the meantime, pending enactment of a framework, we had an experience of a case where this got the angle of a cross-border insolvency got really tested in the existing provisions of Insolvency and Bankruptcy Code. Now, as I mentioned earlier, we don't have an explicit provision or a framework except those bilateral provisions. But nevertheless, the courts and the jurisprudence have moved in such a manner that they have tried to incorporate the framework of a protocol, which is normally entered into between the insolvency professionals through by way of a court order. And that has paved the way for moving this cross-border insolvency in this particular case. Now, just to give you a snapshot of the case background, is that an Indian Airways company was having certain operations and regional operations in Netherlands, and few creditors in Netherlands had approached the Dutch court and applied for a bankruptcy, initiated a bankruptcy proceedings against the Indian company, which has a registered office in India, but a regional hub in Netherlands. The bankruptcy order was passed by the Dutch court, and thereafter, the insolvency proceedings were initiated in India under the Insolvency and Bankruptcy Code. Now, as we all know, the basic objectives of both these processes, there is a conflict, because the liquidation essentially tries to sell the assets and realize the value, whereas the resolution tries to resolve the entity as a whole. So there was a conflicting interest which these insolvency professionals were pursuing. So that necessitated the need for coming towards some sort of a cooperation between the insolvency professional and the Dutch liquidator. This was facilitated by the court when the court, in a matter which went up to the appellate court in India, recommended and put in place, suggested for putting in place, and this ultimately led to a protocol of cooperation which was entered into between both the insolvency professionals, and this got the blessings of the court. And it's on the basis of this protocol the entire resolution process has been able to successfully move. Next slide, please. And we ultimately have a process which is closing to a resolution under this. But this highlights the fact that the cooperation and coordination which we normally achieve under the insolvency framework was attempted on a one-off case like this, even since we didn't have an explicit framework. But nevertheless, the ultimate objective would certainly be to have a proper framework so that we have a much more clearer framework for recognition of insolvency proceedings from other jurisdictions as well. Next slide, please. Thank you. This is to give you a just background of where we stand insofar as adoption of the ancestral model law in India is concerned. Thank you.
Thank you, sir, for highlighting how India is preparing to adopt cross-border insolvency law. Though I would also request Dr. Vishwanathan to kindly throw some light on the concept of adoption of reciprocity during his concluding remarks, because that still remains an issue, if the same should be adopted or not. Now, next I would like to introduce Dr. Paniotis M. Protopsaltis. Dr. Paniotis is a research fellow at Center of American Legal Studies, Birmingham City University, UK. He studied law at National Kapodistrian University of Athens, at the University of Paris II, Pantheon Assas, and at the University of Paris I, Pantheon Sorbonne, from where he holds a doctoral degree in public international law. He has conducted research and contributed to publications in the field of international investment law as well. In addition to his academic work, he is a qualified lawyer in Greece. He speaks Greek, English, French, German, and Turkish. Over to you, Doctor. So you need to unmute, sir.
Can you hear me now?
Yes, sir.
Good afternoon from Athens, Greece. I wish to thank Professor Manta Biswal for the invitation, and I'm very happy to see some familiar faces also on the panel. Now, cross-border insolvency involves debtors that have assets or creditors in more than one country, and typically refers to insolvency of a group of companies. Now, cross-border insolvency raises interesting issues regarding jurisdiction. Which country has jurisdiction to open insolvency proceedings? Can insolvency proceedings be opened in more than one country? Will the proceedings be recognized in other states in which the debtor has assets? Which law is applicable regarding security rights, debtors, cross-border contracts, set of claims? Interestingly enough, it is also an arena where forum shopping phenomena have been observed, debtors seeking to submit themselves to the most favorable forum. In the 2000s, a number of German firms moved the center of their main interest to the United Kingdom in order to profit from the English insolvency law that they considered to be more helpful for their purposes than the German. Now, insolvency rules are not apolitical. They are important domestic policy concerns over economic failure, and the rules mirror national differences in the approach of economic failure. Now, since the early 1980s, beginning from the amendment of the US Chapter 11 in 1971, which replaced an act of 1898, states began to amend antiquated statutes of liquidation to favor the rehabilitation and reorganization of companies. And In addition to that, some four are notoriously favorable to creditors or groups of creditors. And I think the French one is an example. I don't know if my colleague from France can confirm that. Others allow for more flexibility, like the English legal system, with the debt for equity swap mechanism that has been recently introduced also to the French legislation. Now, aside from protecting national interests, like ensuring payment to debtor or pay debts locally incurred, as I've just found out was the case in Singapore, there's a lucrative market for insolvencies, particularly for big groups of companies, when one considers the legal and accountants' fees involved. So some countries may wish to attract insolvency proceedings, and this, it has been said, was the case of the United Kingdom. On the other hand, we are in the era of globalization. The interest lay in favor of a harmonized system of insolvency proceedings to ensure mobility of factors of production, predictability of law, and the like. Whatever the case, the question to ask is whether a debtor should be allowed to benefit from a more favorable form by merely migrating, moving headquarters or statutory seat to another country. Now, the answer to the first set of questions on jurisdiction vary depending on whether we opt for universalism or territorialism. Now, universalism, as we all know, implies that the assets of an insolvent company are administered by a single juridical authority, respective of where they are located, as a court decision may have extraterritorial effect. Universalism is not incompatible with secondary proceedings, wherever assets are located, provided that these are secondary nature. Now, territorialism, by contrast, posits that insolvency proceedings have a purely territorial focus, because this is the way to assure national interest of the state and of its citizens. Now, the original European Union regulation of 2000 and the recast 2015 regulation that succeeded it are examples of universal and international jurisdiction in their territorial scope, of course. The European Union, because the regulation does not deal with the cross-border insolvency matter, extending beyond the state member of the European Union into a non-member state. Now, by contrast, the UNCITRAL model law on cross-border insolvency is an example of cooperative territorialism. It does not establish international jurisdiction, it does not introduce automatic recognition. Both rely on the concept of the debtor center of main interest as the main jurisdictional test, which makes different use of this test. Now, the UNCITRAL model law distinguishes between foreign main, foreign non-main, and domestic proceeding. Foreign main proceedings, proceeding is a foreign proceeding takes place in a state where the debtor has the center of its main interests at the date of the commencement of the foreign proceeding. In the absence of proof to the contrary, this is the debtor's registered office. Non-main proceedings take place in a state where the debtor has an establishment, that is any place of operation where the debtor carries out a non-transitory economic activity with human means, goods and services, in other words, with a minimum level of organization. Now, proceedings commenced on a different basis, such as presence of assets without a center of main interest or establishment, would not qualify for recognition under the model law scheme. Now, the distinction between foreign main and foreign non-main proceedings serves for the recognition of the foreign proceedings for relief purposes. Upon domestic court's determination that the proceeding is a foreign main proceeding, mandatory automatic stay of all proceedings against the debtor, execution against the debtor's assets, and transfer of the debtor's assets. Upon determination that the proceeding is a foreign non-main proceeding, relief is granted, but should be limited to assets that are to be administered in that non-main proceeding. Furthermore, if a foreign main proceeding is pending, any relief granted should be consistent with the foreign main proceeding. Recognition itself is not automatic. The model law submits recognition to the public policy test of the enacting state and mainly provides for recognition to be granted as a matter of course if the application meets the requirements of the model law. But what is most important is the recognition of the preeminence of domestic proceeding over the foreign proceeding. In other words, the principle of territoriality. Now, unlike the model law, the EU regulation is a unique example of universalism for a defined jurisdiction on the basis of the debtor's center of main interest. On the one hand, the regulation provides that the courts of the member state within the territory of which the center of the debtor's main interests are situated shall have jurisdiction to open insolvency proceedings. The center of main interest shall be the place where the debtor conducts the administration of its interest on a regular basis and which is ascertainable by third parties. And this place shall be presumed, but this is a refutable presumption, that the place of the registered office is the center of the main interest of, in the absence of proof to the contrary. Now, those proceedings shall have universal scope and arranging that they compensate all debtors' assets. There seem to be two exceptions from universalism. The first relates to secondary insolvency proceedings that may be opened in a member state where the debtor has an establishment. I think my colleague spoke already about that. And the second relates to insolvency matter not regulated by the law of the foreign member state within the territory of which the center of the debtor's main interests are situated. For example, rights of in rem of creditors, the movable or immovable assets involved. On the other hand, the regulation provides that any judgment opening insolvency proceedings handed down by a court of a member state which has jurisdiction shall be recognized in all other member states, so automatic recognition. The second issue that I have mentioned is forum shopping. Both the UCITRAL model law and the EU regulation contain some minor safeguards in relation to migration of corporations to avoid moving headquarters or statutory seat to another country. The model law provides for the location of the center of main interest to be defined at the date of commencement of the foreign proceedings. The EU regulation provides for the center of main interest to be the place where the debtor conducts the administration of its interest on a regular basis and which is ascertainable by third parties. The recast regulation now contains a suspension period under which the presumption of the center of main interest shall only apply if the registered office has not been moved to another member state within a 3 months period prior to the insolvency proceedings. Now, the United Kingdom applies both the EU regulation and the model law. The first, obviously, within the European Union and for approximately 12 days, for the next 12 days, until Brexit comes. Now, the second, with the countries abroad, essentially the Commonwealth. The attitude of the British in relation to both the model law and the regulation have been ambivalent. The United Kingdom participated in the first European attempts of the 80s for a convention on insolvency proceedings of the European Union, which to many extent offered guidance to the drafters of the UCITRAL model law. And the convention provided for universalism. And the British supported, of course, the universalism, cross-border recognition of bankruptcy proceedings since the early 19th century. Actually, they have invented it. But they were afraid of the potential loss of jurisdiction that we're exercising currently when the debtor had assets in the United Kingdom, but he didn't have a center of main interest or an establishment. Now, the United Kingdom recognized the benefits of the European Insolvency Convention, but it refused to sign the third and last draft for other reasons. At the time, Germany and Finland redrafted it in the form of a regulation to which the British government reluctantly subscribed. It turned out that the British benefited from the regulation, for English courts were being very successful in attracting insolvency cases into their territory. A tendency exemplified by the case. Sadly, there are only 13 days left until Brexit puts an end to the application of the regulation. The United Kingdom has already put in place new regulation for the event of no deal, and will be under the new regulation. There will be no need to recourse to the center of main interest concept, but also there will be no automatic revocation. Thank you very much.
Thank you so much, sir. Next, we have Mr. Gabriel E. Messina. He's teacher in charge of assignments, Commercial Law 2, and also a teacher in charge of assignments, Economic Analysis of Law at the Law School, National University of Rosaria. I request sir to please address the attendees.
First, I want to thank Professor Dr. Guzman for her kind invitation, and also to the chairman and the organizers of this great event. Cross-border insolvencies in Argentina give rise to many controversial questions. Although this situation seems to be common in other parts of the world, Argentine regulation provides more doubts, uncertainties, and is very scarce. So some preliminary statements can be useful. Argentina has not adopted the UNCITRAL model law. We have made some attempts, one in 2002, another one in 2018, 2 years ago. We presented a reform bill to the Argentine bankruptcy law, or ABL. This regulation would have been inserted in the text of the ABL, wouldn't have been inserted, but would have remained in a special law. So, many problems of cross-border insolvencies do not have specific provisions in the law, and they have never been decided by judgments that could serve as a precedent. Some other problems have specific provisions in our legislation, but frequently the interpretation of those rules remains within the field of doctrinal controversy. Finally, only a few questions have a predictable solution, since they do have legal provisions and they have been applied by the courts. About the legislation, we can say that there are two different regimes for cross-border insolvencies in Argentina. One deriving from international sources contained in the Montevideo Treaties of 1889 and 1940, and the other from national sources contained in the ABL Argentine bankruptcy law. The Montevideo Treaties of 1889 and 1940, this last one signed 80 years ago, do not unify the insolvency laws of the countries that are party to them. The Montevideo Treaty of 1889 is binding for Peru, Colombia, Bolivia, Paraguay, Uruguay, and Argentina, while the Montevideo Treaty of 1940 binds solely Argentina, Paraguay, and Uruguay. Brazil and Chile, our main economic partners in the region, are not part in those treaties. So, cross-border insolvencies with international elements from any other country of the world are dealt in Argentina by the rules contained in the ABL, mainly rules 2, 3, and 4. To make a quick approach to the Argentine insolvency framework, we can say that the ABL applies to legal entities and individuals. It excludes public entities as well as insurance companies, pension funds, financial institutions, all of which are regulated by special regimes. There are three main insolvency proceedings: out-of-court agreements or workout, acuerdo preventivo extrajudicial, reorganization proceedings o concurso preventivo, bankruptcy or liquidation proceedings, quiebra. The out-of-court debt restructuring instrument has been incorporated into the ABL in 2002, and it can be said to be similar to the prepackaged restructurings in the United States. The reorganization or concurso preventivo is a remedy by which the debtor obtains financial relief through a judicially supervised reorganization proposal made to its creditors, similar to the Chapter 11 proceeding under U.S. Bankruptcy Code. And finally, we have liquidation. The purpose of the quiebra is the liquidation of the debtor's assets in order to distribute the money thereby obtained among the creditors. To give a broad idea, one can say that it's similar to Chapter 7 proceeding under the U.S. Bankruptcy Code. The differences between reorganization and liquidation proceedings are important under Argentine rules for cross-border insolvencies. But let's see the provisions of the ABL. First, the Argentine court's jurisdiction over insolvent debtors domiciled abroad. Argentine insolvency law applies in principle to debtors domiciled in Argentina. Citizenship or nationality are of no consequence, given that the national constitution of our country establishes equality under the law for all inhabitants, those who have fixed their residence in Argentina. Thus, in principle, Argentine courts have no jurisdiction over debtors domiciled abroad. However, a special rule establishes an exception to the latter. In the case of the debtor domiciled abroad who has assets in Argentina and obligations payable in this country. Such being the case, local creditors, the owner of credits payable in Argentina, may file a petition to initiate the bankruptcy liquidation proceeding of their debtor. The Argentine court may declare the bankruptcy, but with limited effects. The effects of this type of bankruptcy remain within Argentine territory. The status of the debtor is not affected. There is no disqualification for the bankrupt person. And also, the sole purpose of this liquidation of assets are placed in Argentina in order to distribute the proceeds among local creditors according to the rules of Argentine insolvency law. Also, we have provisions about the effects of foreign insolvency proceedings in Argentina. The first rule is the territoriality of the foreign bankruptcy order. The foreign bankruptcy proceeding may not be invoked in Argentina in order to dispute the rights of local creditors enforceable on assets in Argentina. Neither may the foreign bankruptcy proceeding may be invoked to set aside or make voidable the acts carried out in Argentina by the debtor. The second rule is limited extraterritoriality of the foreign order for commencement of insolvency proceedings. The foreign insolvency judgment order opening the insolvency proceeding in general in another country may be used by local creditors and by the debtor himself in order to obtain the commencement of quiebra, liquidation or bankruptcy proceeding in Argentina. In this case, evidence of the debtor insolvency need not to be produced. The foreign insolvency judgment in this way has extraterritoriality, but this validity is limited. It may only be used as an act of bankruptcy in Argentina. And now, this is a particular state of affairs, given the general rule and the ABL is that the creditors who file for the liquidation must prove the inability of the debtor to meet obligation as they can do. Also, we must address the situation of foreign creditors in Argentine insolvency proceedings. After the amendment of the ABL in 1953, the discrimination of foreign creditors in Argentina proceedings has been significantly reduced. However, some discrimination still remains. According to the ABL, the differences between foreign and domestic credits lies in the following criteria. Foreign credit is the credit payable solely outside Argentina, and domestic or local credit is the credit payable in Argentina. Credit with two more alternative domiciles of payment even when the option is with the debtor, should be considered domestic credit in Argentina. About the proof and acceptance of foreign credits, we apply the rule of reciprocity. The acceptance of foreign credits in Argentine insolvency proceedings make it essential to produce evidence that a similar but domestic credit should be recognized, accepted, and could be collected in the same conditions in insolvency proceedings in the country where the credit is payable. The principal problem of the construction of this rule has been to determine who has the burden of proof of the foreign law. Although the terms of the ABL Rule 4 are impressive, it may be observed that the judicial construction of this topic tends to be broad and flexible. Also, we must point out that the secured creditors are excluded of the rule of reciprocity. The creditors with garantía real, like mortgages or pledge, do not have to produce evidence of the foreign law as the unsecured creditors must do. Once the foreign creditors' claim has been accepted in the Argentine insolvency proceedings, different situations arise regarding the collection of these credits. Where the Argentine proceeding is a reorganization, concurso preventivo, there is no discrimination between domestic and foreign credits. But where the Argentine proceeding is a liquidation, we have two situations. First, there is no discrimination when the foreign credit does not belong to another foreign bankruptcy proceeding. But if the foreign credits also belong to foreign bankruptcy proceedings, the rule of local priority applies. The effect of this rule of local priority is the subordination of this type of foreign credit to all classes of credits. In liquidation proceedings, this type of foreign credits can be collected after the total amount of credit of all prior classes and degrees has been satisfied. So, when this subordination rule is applicable, the collection possibilities are in fact non-existent. Finally, I want to make a quick note about COVID-19 and the reform to the ABL in Argentina. The Argentine government considered it necessary to have the legislation adapted, especially as a consequence of the pandemic and mandatory isolation. In this regard, there were at the moment 14 reform bills under debate in the Argentine Congress, but one was approved last October. One of the most important effects to be highlighted is the suspension of the deadlines in the bankruptcy proceedings in process, delegating to the judge the readjustment of the schedule. Another effect that must be pointed out is that it suspended all judicial and extrajudicial auctions, including mortgages, pledge of any origin. In few words, the reform postponed many deadlines in order to help companies through a crisis. But in my opinion, although well-intended and in line with reforms in other countries, this reform will intensify the debt dilution effects of our ABL. In conclusion, we can say that the Argentine bankruptcy law has an old cross-border insolvency regime, more aimed at bankruptcy than reorganization, and does not solve the main problems of transnational insolvency. None of the provisions of the UNCITRAL model law is contrary to our national constitution, nor to the fundamental principles of Argentine law or its public order. On the contrary, it will be convenient to adopt it so as to update our obsolete rules of private international bankruptcy in line with the most modern trend. And at the same time, would give our country an important signal of predictability and legal certainty to foreign investments. Thank you.
Thank you so much, sir, for giving us an insight of all the provisions of Argentina law. Next, we have Professor Jason Kilburn. He's a leading authority on comparative law and policy of individual insolvency. He has written numerous articles and a book on comparative bankruptcy for consumers and individual entrepreneurs. He has also co-authored a book on international cooperation in cross-border business bankruptcy and restructuring, and he is a national reporter and co-editor of a series of detailed comparative analysis of business reorganization practices around the world. He has advised several national governments on personal insolvency reforms. He was also appointed as an advisory commissioner of the Seoul Bankruptcy Court's Administrative Committee, and he has served as a short-term consultant on several World Bank Group advisory projects. We are pleased to have you, sir, and I request you to please address the attendees.
Well, I am so pleased to be here. Good evening. I'm so honored to have been invited to this great conference celebrating UNCITRAL's model law on cross-border insolvency. The U.S. Adopted the model law in our new Chapter 15 of the Bankruptcy Code in 2005. So we've got some experience under our arms. The law has been broadly embraced. It has worked quite well. It's quite possible for a country to cooperate with others in insolvency proceedings. And the U.S. courts have been very ready, generally, to cooperate with foreign representatives, with a few notable exceptions. And that's what I want to concentrate on today, talking a bit about the challenges of the new cross-border insolvency law, in our case, particularly related to disputes about intellectual property and discovery rules. We're going to see we've got some in the United States, still some localism. And these cases reveal some remaining challenges for cooperation, even in countries like mine that have aggressively supported this new law. And they show, by the way, that adoption of the model law does not necessarily mean sacrificing local values in deference to foreign laws or interests. One can maintain one's local dedication to one's local interests. I'll mention 4 cases as examples. The first 2 cases involve refusals by U.S. bankruptcy courts to cooperate in the context of intellectual property licenses. The first one is a particularly famous one. After having been recognized by the U.S. Bankruptcy Court as the foreign representative of the German insolvency proceedings of a semiconductor manufacturer called Qimonda, with a Q, Qimonda, the administrator asked the U.S. court to recognize that German insolvency law allowed the administrator to reject and take away the rights of patent licensees in order to allow those licenses to revert to the bankruptcy estate so that the administrator could extract more value from them. And German law did not specifically protect the rights of the licensees of those patents. So the German administrator asked the U.S. bankruptcy court to cooperate in sending those license rights back to administration in the German proceedings. Now, ordinarily, Chapter 15, the model law, envisions precisely this kind of cooperation with a foreign representative, but with 2 important provisos. As we heard from the Indian representative a couple of moments ago, cooperation is mandated only if the interests of creditors and other interested parties, including the debtor, are sufficiently protected on the one hand, and in particular, the courts can refuse cooperation if that would be manifestly contrary to the public policy of whatever country is involved in our case, of course, the United States. The bankruptcy court initially wanted to follow the rules and cooperate with the German representative, but the appeals court sent the case back, and the bankruptcy court had to conclude that cooperating with the German entity in this case run afoul of both of these provisions that I've just mentioned, allowing the court not to cooperate. The court found that allowing the German administrator to take away the license rights, particularly of U.S. licensees, would not properly balance the interests of those U.S. licensees and the German debtor. And by the way, U.S. law has a sort of extraordinary provision in our Section 365N of our bankruptcy code that specifically provides for protection of patent licensees. And the court found, oddly enough, that sort of obscure provision was a fundamental public policy of the United States, and therefore made it not possible for the bankruptcy court to cooperate with the German administrator. It was quite a surprise in that the U.S. had been very aggressive about advancing Chapter 15 and cooperating with foreign representatives, only to be concluding that this obscure provision then prevented that very same cooperation. Even more surprising, in the second case, which so starkly contrasts with that first one, a few years later, a Korean solar panel manufacturer called SMP Limited was a joint venture between an American company and a Korean company. The cornerstone of SMP's business was a license from Sun Edison, a US company, to allow the Korean company, SMP, to use patented polysilicon production technology at its plant in Korea. The license, though, like many patent licenses do, contained a provision that allowed the licensor to terminate the agreement as soon as the other party, the licensee, declared bankruptcy or failed to pay its debts. That's called an ipso facto clause. Ipso facto, simply by virtue of the fact that the party has sought bankruptcy, the license may be terminated. SMP went into rehabilitation proceedings in Korea, a debt rehabilitation and bankruptcy proceeding in Korea in May 2016. And consequently, Sun Edison, the licensor, notified SMP that it was terminating that license in light of that ipso facto clause that said, if you go into bankruptcy, I can take away your license rights. Now, both Korean law and US law, incidentally, vitiate these clauses. Both countries' laws say these ipso facto clauses allowing a licensor to terminate a patent license simply because the licensee has gone into bankruptcy are invalid. And so SMP came to the United States, asked the New York Bankruptcy Court to apply Korean law, which, just like its US counterpart, says these ipso facto clauses are not allowed and the license should not, therefore, be terminated. But totally surprisingly, the court denied this request. It observed that New York state law, strangely, allowed ipso facto clauses. And when SMP replied by simply asking the New York Bankruptcy Court to observe comity with foreign law without referencing Chapter 15, unfortunately, the New York Bankruptcy Court was unmoved by this sort of general and weak appeal to comity. One lesson from this case might be that you've got to cite the particular law that you're relying on that actually does help you if you want the court to help you. But that the New York court would have understood, as it clearly did, that both Korean and US law forbids this kind of thing, and yet nonetheless the court refused to cooperate, was quite a surprise. These two cases, it seems to me, begin to illustrate that the US courts are surprisingly quick to abandon cooperation when the interests of US parties, particularly to IP licenses, are at issue. Now, those cases are not necessarily representative. They don't represent the position of the US. Most US courts have been very, very cooperative, but it's an interesting point to observe. The other two cases, then, stand for a similarly contrasting dispute in another context, and that is information discovery. The first one here presents a classic battle between the quite famously intrusive US procedure of information discovery and the much more restrictive approach taken by most other countries, in particular those in Europe, in particular France. So in this case, when a Canadian creditor attempted to enforce a Canadian judgment against a French shipping company called SNP Boat Services, which was in, at that time, French insolvency proceedings, Sauvegarde, it had the great fortune of finding in the United States and seizing a boat called the MX-65. And so the French court, unfortunately, had decided that that Canadian judgment, which the creditor had enforced to seize the MX-65 boat, had been invalid for some reason. But nonetheless, the Canadian creditor asked, well, no, it was SNP, the debtor, asked a Florida bankruptcy court to set aside what the Canadian creditor had done and to turn that boat over to the French administration for administration in those proceedings. Normally, of course, that kind of request would be granted. This is exactly the kind of thing that one sees in Chapter 15, particularly where the only connection that the United States has to the case is one minor asset like this one boat. But the Canadian creditor here asserted that its entitlement to a fair airing of its claims, its due process, had been violated in the French proceeding, and that the U.S. should disregard those French proceedings. The Canadian creditor demanded that SNP, the French company's foreign representative, turn over the French court file and subject the debtor's management to a sworn deposition and interrogation and interview in the U.S. proceedings. SNP, the debtor's representative, refused because French law, quite famously, has what's called a blocking statute, which prevents French company representatives from complying with the U.S.'s very intrusive information discovery rules. And when the U.S. Bankruptcy Court found out about this, the Florida Bankruptcy Court refused to extend this statutorily required cooperation to the foreign representative, concluding simply that, well, the wisdom of cooperating with a foreign representative becomes questionable, the court said, when U.S. discovery procedures are resisted. The statute, of course, as I've just mentioned, contains an exception for matters that would be manifestly contrary to the public policy of the United States. But notice the court in this case didn't invoke that provision. It simply rejected cooperation with the French proceedings with apparently no explanation. This was a real surprise, as was the following case, which of course refuses cooperation in the opposite direction again. The final case that I'll talk about comes from Germany. It involved a German orthopedic surgeon named Jürgen Toft, who was in insolvency proceedings in Germany. He had allegedly hidden his assets and fled the country. And so his creditors, including the German insolvency representative, very much wanted to know where Dr. Toft had gone and where he had left his assets. And so the German insolvency representative came to the United States and sought emails that might reveal where Dr. Toft's assets were and where Dr. Toft's person might be. The German insolvency representative asked a New York bankruptcy court under Chapter 15 to order U.S. internet service providers to turn over Dr. Toft's email correspondence. The New York Bankruptcy Court, here again, very surprisingly, refused to cooperate with the German foreign representative, concluded that complying with that order would violate a variety of U.S. privacy protection laws that apparently, in the judge's view, represented fundamental U.S. public policy. This is extraordinarily surprising, given that European law generally protects individual privacy far better than U.S. law. It's not entirely clear exactly which U.S. laws were allegedly violated by having these internet service providers turn over email, because this happens all the time in the United States. But once again, this is another example, another notable example of a situation where a U.S. bankruptcy court concluded that cooperating with a foreign representative would be manifestly contrary to the public policy of the United States. So once again, for better or worse, these cases represent that the model law does not necessarily force adopting states to abandon their local policies and their local preferences, or to sacrifice protection of local interests. This is fairly certainly not what the drafters of the model law intended, but it is a reality now firmly established in U.S. cross-border insolvency practice under the model law. Thank you so much for having me. This is a real delight, and it's a great pleasure to celebrate UNCITRAL's model law on cross-border insolvency with you all.
Thank you, everyone.
Yeah.
Unfortunately, now we are heading towards the end of the session. And we would now request our chair, Dr. Vishwanathan, to please share his comments and observations on today's deliberation. Over to you, sir.
Thank you, Advaita. We had a very interesting session, and we had a global view of how these cross-border insolvency issues are being dealt with by different jurisdictions. We had first Professor Meng C. who explained as to how Singapore has adopted the model law and what were the difficulties they were facing, and how they were quick in responding to coming up with different laws like restructuring hub committee's report, and then how to emerge as a major restructuring hub of Asia. Next, then he also threw light about how Comey was a big issue in two important cases, Jetta Jet and Rooftop, and he also explained the difficulties in dealing with the Comey issues which you are bound to face. Then we had Professor Lafi from Jordan, who explained the main challenges of this conflict of proceedings in Jordan. He shared his experiences. It was very instructive to learn from them. And then we had Professor Leon Truckman and Professor Robert Walters, who had given us a detailed exposure about the advantages and the provisions of the model law and how we should follow. Then we had Professor Stefani talking about the French experience, though French is not a party to the model law, within the EU, how they deal with the cross-border issues and how they deal with non-EU companies. And she also took up on how the pandemic, how they responded to pandemic, and what are the special measures they took up in the matter of fixing of dates for session of payments, etc. It was very instructive. Then we had Dr. Rajendra Prasad from Mauritius, how he gave us a Mauritian professor, and where they have adopted the modern law, and where they blended the English law and the French law, the civil law, and that's an experience in itself. And he also went along to explain how it is advantageous. Then we have the Indian view, where Unikrishnan gave us a very bird's eye view of how the Insolvency Committee deliberated on this incorporation of the model law into a system. And then we also drew attention to the question of reciprocity. We never wanted reciprocity to be insisted for a simple reason. India is emerging as a big investor company. Our companies are going outside and investing. It's not you may have an advantage in resisting inbound requests, but outbound requests will have a disadvantage if you insist on reciprocity. That is the only thing. But as Unikrishnan said, it's only a temporary measure to start with, and as time goes on, we could give up reciprocity. He also enlightened us about the recent case of jet airways, where the judicial innovation has evolved protocols and how it is tackling issues, even though the absence of a model law. Then we had Dr. Panayiotis from Greek experience. He explained how the FOMI is causing problems and how to deal with them. Then Professor Gabriel from Argentina, where they are grappling with this problem even without a model law, and the numerous problems they are likely to encounter. And at last we had Professor Jason Kilburn, US experience, which we learned many things from US experience, and he was very bit surprised how the US courts are not cooperating in two issues regarding the IPP protection and causes of discovery, and we stand to gain by these exposures, and I'm very sure that this the conference this roundtable has been a very instructive one. I think all of us have learned something which will be useful for us for implementing this law. And thank all the participants for their time joining us from across the globe. Thank you, thank you, thank you.
Thank you, sir. I request Dr. Mamta Biswal ma'am to kindly give her observation for today's deliberation.
Thank you, Advita. I think the chair of the roundtable, Viswanathan sir, has covered everything. But I think we all will look forward once the latest committee that is referred by Krishnan sir, that KP Krishnan committee report about the rules and regulations, and while comparing with the other jurisdictions, cross-border insolvency law, and particularly what we heard from all the speaker, in 3-4 jurisdictions where it is not adopted and where it is adopted, the common issues are there. And today's roundtable relating to our concern. So one is this, and another I can foresee that the international contractual issues, like sometimes the people, the parties from India and other country, when they use the different incoterms and they use different clauses in the international contract where we don't have any particular law. But at the same time, if that is the part of the insolvency resolution process, then there may be a chance of conflict of law. That is what I foresee. And there are few issues like, say, arbitration agreement, arbitration clause in the arbitration agreement, then the different international contract where we don't have any law. Once the report is out, I think we will be in a position to do research and deliberate upon those reports. But at least we are in a stage that we are moving towards the adoption of the cross-border insolvency model law by UNCITRAL. And another point I could foresee that like the CPC 44 clause A, the countries who are listed. So here also one thing, today we have 48 countries party to the UNCITRAL model law with 51 jurisdiction. But if the parties are from countries of UNCITRAL model law and who have not adopted, so in those cases, what will happen? Another is this territorial theory versus universal theory. So some countries, they follow the territorialism, some countries follow universalism. Suppose the different countries with different theory, then in that case, how to bring uniformity and harmony. So those are very remote issues which I think today we should not think, but I see that those are few issues which also can happen, which I have gathered from different judgments of different countries. So we will see what will be the implementation and application of the new proposed law. But anyway, it is a very welcome step by the government of India to adopt the UNCITRAL model law. I think we are already late and I should not take more time. And I think we will take this conference for further research. Maybe in future we'll meet again and to discuss the development that time. Thank you so much. And my sincere thanks to Viswanathan sir and Rajesh sir will propose vote of thanks. I should not encroach upon. Thank you so much.
Thank you so much, ma'am. As we conclude the session, I request Mr. Rajesh Kumar Gupta, who is a seasoned banker with over 32 years of experience in banking, financial service, regulatory, and automotive industry. Mr. Gupta was employed with the leading manufacturing, consulting, and BFSI organizations, including Eicher Tractor Limited, Maruti Udyog Limited, and Reserve Bank of India, along with Small Industries Development Bank of India, Oracle Financial Software Solution Limited India, and IFCI Limited. He was the Chief Risk Officer of Government Financial Institute (IFCI) prior to joining IBBI. Currently, he is Chief General Manager with the Insolvency and Bankruptcy Board of India. I request Sir to kindly deliver the vote of thanks for the concluding.
Thank you, Advita. A very good morning and good afternoon and a good evening to all the distinguished panelists and the participants. On behalf of IBBI, I would like to thank all the speakers for their edifying and insightful addresses. Dr. T.K. Viswanathan, Chairman BLRC and former Union Law Secretary, India, chaired today's virtual roundtable on cross-border insolvency and shared his experience as a chairperson of the BLRC and also raising the current concerns. He mentioned how the IBC was enacted in 2016 after two abortive attempts and after long deliberations and including concerns of several stakeholders. He mentioned that only two sections are available to address the CBI, that is the cross-border insolvency issues, under the existing code, and that also under the bilateral agreements. I would also like to extend my thanks to Professor Dr. Mamta Biswal, Professor of Law, Dean, Faculty and Academic Affairs, Head Center for Corporate Insolvency Law, GNLU, for co-chairing this event and putting the things in the right perspective. Professor V. Ming Seng, Republic of Singapore, in his address articulated the cross-border insolvency law of Singapore by giving the background to adoption of model law. He also dealt with the abolition of ring fencing. He emphasized on the model law, which was adopted by the Amendment Act of 2017, and how the Singapore insolvency laws and model laws coexist. He also dealt with the judicial pronouncements, wherein a pragmatic approach is considered to promote cooperation in cross-insolvency. He also touched upon the international trend prevailing. Professor Lafi, Kingdom of Jordan, articulated on the rules which govern the insolvency laws of Jordan as part of commercial law. Professor Lafi dealt with three stages of insolvency issues. He also stated that not many cross-border cases exist in the country as of now, but a lot of possibility may be seen in future. He mentioned about several challenges like role of creditors, role of debtors, etc., which are caused by complex law procedures in Jordan. He also dealt with the rules as per the new insolvency laws and cross-border insolvency. It is yet to be seen whether foreign courts will recognize the Jordan decisions and vice versa. The importance of reciprocal issues were also touched upon. As of now, there is no specific law which governs the cross-border insolvency in Jordan. Professor Dr. Leon and Robert Walters, Commonwealth of Australia, in their address explained the principles with respect to the cross-border insolvency in Australia and also touched upon the impact of COVID-19, which has caused a global shock. Their presentation was on should the UNCITRAL model law on cross-border insolvency be afforded convention status. Dr. Robert also touched upon various legal mechanisms for restructuring and reorganizing the companies. He discussed the core objectives of cross-border insolvency and what it all comprises while focusing on various chapters. He discussed the discretionary collective relief universalist approach to cross-border insolvency, concentration on reconciliation, and encouraging greater concentration on cross-border insolvency. There are highly successful UNCITRAL models which can be replicated to strengthen the current governance framework in cross-border insolvency is what was mentioned. Professor Stephanie of the French Republic effectively addressed the cross-border insolvency in France vis-à-vis the European Union. France and Germany and most of the larger countries in EU have yet to adopt the model UNCITRAL law. Only very few small countries like the Greece, Poland, and Romania with low economic power had adopted the law as of now. She dealt with the cross-border insolvency between European Union member states, where she captured upon the procedures of the insolvency, the structure of the procedures under the EU law. Bilateral treaties were replaced with the cross-border insolvency regulations in 2015. She also very well differentiated the principle of universality and principle of territoriality, which are the two fundamental principles of international insolvency law. Professor Stephanie also explained the governing law of France. It has the cross-border insolvency laws for EU member states. To try to limit bankruptcy and job losses on account of COVID pandemic, various measures have been initiated by the French government. The measures applicable, they are applicable up to December 31, 2020, though they may be extended. So France now has lesser insolvency procedures compared to the earlier years. Dr. Rajendra Prasad Gunput from Republic of Mauritius detailed the Mauritian perspectives, wherein he stated that the model law is adopted by Mauritius and it is very successful. He also touched upon various domestic legislations like the investment disputes. Dr. Gunput further discussed the United Conventions on Contracts for the International Sale of Goods. He also explained various covenants signed by Mauritius. The Mauritius legal regime was also elucidated by him, which is a mixed one based on English law, French law, and the model law. Model Mauritius law on CBI, that is cross-border insolvency, is principally based on the UNCITRAL model laws. He also dealt with the Companies Act 2001 and Insolvency Act 2009. Mr. Methil Unnikrishnan from India, while highlighting the current legal framework in India, emphasized upon the applicability of the model law in 4 specific frameworks. He explained the background by touching upon the procedures under the IBC, Insolvency Bankruptcy Code 2016, the enforcement of foreign judgments in India, and treatment of Indian proceedings and judgments abroad. Mr. Unnikrishnan highlighted the shortcomings of the existing legal framework and very well analyzed the recommendations of the Insolvency Law Committee and key principles which were recommended by the said committee. The CBIRC was also touched upon by Mr. Unnikrishnan. The analysis of Jet Airways case as a case study explained by him was very insightful on the alternative objective to have a proper framework of insolvency proceedings from foreign jurisdictions. His address gave an understanding about where India stands today on cross-border insolvency issue and how India is working towards enactment of the cross-border insolvency laws. Dr. Panayiotis of United Kingdom of Great Britain and Northern Ireland shared his perspectives on insolvency laws and cross-border insolvency in a very comprehensive manner. He explained the domestic policy concerns and also talked about the economic failures. He mentioned that the insolvency laws are territorial in nature. Dr. Panayiotis also touched upon the European regulations and talked about territorial jurisdiction and recognition of the proceedings, wherein he also talked about the main jurisdictional test. Rights of creditors and other stakeholders were also discussed. Mr. Gabriel from Argentina Republic mentioned that Argentina has not adopted the model UNCITRAL law despite making 2 attempts over a period of around 15 years. He talked about the US insolvency laws and articulated the Argentinian insolvency laws in a detailed manner. He also addressed the situation of foreign creditors in Argentina. The rule of reciprocity is applied in Argentina, and finally concluded by briefly describing about the impact of COVID-19 on the insolvency laws in Argentina. Measures including suspension of the insolvency proceedings have been initiated to address the COVID pandemic. He concluded also by saying that the model law is not contrary to their domestic laws, and it may be good to adopt model UNCITRAL law on cross-border insolvency to bring certainty to foreign investments in Argentina. Last but not the least, Professor Jason Kilburn of the US articulated the adoption of model laws. He discussed certain case laws and case studies that emphasized that model laws do not force any country to abandon their domestic laws. He emphasized upon the ipso facto clause, information discovery. One can maintain local laws and interests and flavors even with the implementation of UNCITRAL model laws. He supplemented his address by including details of several good examples in various geographies and jurisdictions. In the end, I would like to conclude by thanking Gujarat National University and Dr. Professor Mamta Biswal for organizing this international conference, the eminent speakers, Ms. Adwaita Sharma, and participants once again for taking time out of their busy schedules and joining the webinar today and making the event a useful learning experience. We look forward to many more such learning engagements in future with you all. Thank you, everyone. Thank you very much.
Thank you.
Thank you, everyone. Have a safe year ahead. And good night.
Good night, Adwaita. Thank you. So, thank you. I'll end the meeting now.